Good morning, everybody.
Good morning, Commissioner Byrd.
Good morning.
How are you, Commissioner
morning.
Fishman?
I'm hanging in there. How about you?
I'm good.
Go ahead.
There was a lady voice that said good morning. I can't picture who it was.
That was me. It's Sarah. Good morning, Commissioner
Yes,
Byrd,
it was
Commissioner
you.
Fishman.
Good morning, Sarah.
Good morning,
And there was
lady Sarah.
Was there Brad Borman say good morning?
I did not, but I am now.
I heard another good morning from a fella, and trying to figure out who said that.
Good morning.
Hans. And I know Commissioner Maestas is on, but he won't say good morning. I'm offended and hurt.
Well, that was me. I disguised my voice, trying to throw you off.
Good morning, Commissioner Maestas.
Good morning, Commissioner Byrd and everyone.
Yes.
Well, Commissioner Byrd, we've had many discussions about how sensitive you are and how easily hurt. And it seems that no matter how hard we try to protect you, you still get hurt. Should we just give up?
No, you're just not doing enough.
Okay. Just examining the options.
Right, there's always options. So is everybody supposed to be getting rain on Friday?
Thursday for us.
Thursday for you? Thursday night, Friday morning is what we have down. We'll see.
We
could use it.
Yeah, well, we've gotten a lot of rain down here, and normally we're a desert, but right now we're this verdant grassland. It's beautiful.
Yeah. We've got tons of fuel for fire right now. So a little rain would help quench that a little. Every time a fire call goes out, a whole bunch of people respond now just because of the fear that it's going to turn into something major.
Yeah.
Last summer, this time we didn't care because there was nothing to burn.
Okay, Sarah, can we get the agenda on the screen here?
Yes, sir, right now.
Okay, thank you.
Oh.
There we are. Thank you.
You're
And
welcome.
we're ready to start the meeting. And I'd like the call to order and roll call. Mike, are you here today?
I am.
Good morning, Mike.
Good morning.
Welcome back.
Thank you.
Time to call us out.
I'll call the roll. Commissioner Byrd,
No. You're in the wrong order.
Commissioner Vicente Aguilar,
Here.
Commissioner Hall,
Here.
Commissioner Maestas,
I'm here.
Commissioner Fishman.
Here. And
We have
Go
5
ahead.
commissioners present. That's a quorum. The commissions can hold this open meeting.
okay, I just wanted to note that Commissioner Byrd appears to be friendly this morning, but also feisty. So everyone be warned. And you've earned the opportunity to lead us in the pledge as only you can, Commissioner Byrd.
I'll be honored. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures.
See, you outdid yourself. Thank you.
Yes, sir. Thank you.
Consideration and approval of the agenda.
So moved.
Correction.
Commissioner Byrd?
We have an item we need to remove.
Oh, yes, that's right. Yes. I believe Mr. Chair, I believe item number 210083-UT in the matter of the application of Public Service Company of New Mexico for decertification and abandonment of 114 megawatts of leased Palo Verde nuclear generating station capacity and sale and transfer of related assets, and for approval to procure new resources under 17.9.551 NMAC.
I will second the agenda as amended.
Yeah, that will be removed. Thank you.
Okay. Mike, would you please take the roll on the amended agenda?
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Byrd.
Aye.
The agenda is approved by a vote of 5-0, and thank you to Commissioner Byrd for interrupting before I did to bring up the issue of removing that one item.
Okay. On to introduction. I don't know what that is. Introduction of special guests. Sarah, do we have anyone?
Mr. Chair and Commissioners.
Even if they're not special.
Yeah.
We don't have any special guests or public comment this morning.
Okay. Commissioner Byrd, unspecial guests were not on the agenda, so we would need an amendment to the agenda for that. Public comment.
No public comment this morning either, Mr. Chair. Or
Okay,
Commissioners.
thank you, Sarah.
You're welcome.
And we're on to discussion and potential action. And we're going to lead off with our esteemed Chief of Staff. Wayne, take it away.
Thank you, Mr. Chairman. I resemble that remark.
Very modest of you.
Yeah, indeed.
He resembles it, but the E shouldn't be there.
Okay.
I know better than to provoke Commissioner Byrd when he's in a mood like this. So I'll get back to playing the straight guy.
There you go.
Mr. Chairman, members of the commission, good morning. It's nice to see you all. This is a follow-up from the discussion that we had last week. We are proposing several additional appropriation requests to go along with the FY23 appropriation request that the commission has already approved. I'm not going to spend a lot of time on this because, again, we discussed it last week. But essentially, Mr. Chairman, we are asking for additional budget adjustment request authority for both FY22 and FY23 that will allow us to make program transfers. And that actually is very important, particularly for this year. If we had program transfer authority already for FY22, our budget situation wouldn't be quite as tight as it is. But we're going to ask for that authority for both fiscal years 22 and 23. We're also requesting a special appropriation for FY22 to cover an expected shortfall in personal services and employee benefits for the current fiscal year. A special appropriation for FY22 to allow us to properly furnish and move into our new office space. And then for the next fiscal year, in addition to our appropriation request, which is about a 14% or $1.4 million increase over the current fiscal year, that appropriation request will allow us to fill all of our current positions. But in addition to that, we are requesting that additional bar authority as well as the authority to retain up to $500,000 in fees under the Community Solar Act in order to fully staff up for that important program. And with that, Mr. Chairman, happy to answer any questions. If the commission decides to approve these requests, that will officially kick off our full court press for the upcoming legislative session. We're anticipating 2 hearings during the interim one before the Water and Natural Resources Committee, in which we will discuss this request as well as our FY23 request. Expect that to be on October 21st. And then tentatively, we've been informed that our Legislative Finance Committee hearing is scheduled for November 17th. So lots of discussions will be had between then and now with legislators and getting their support. So some of that has already happened, but I think these are solid requests. I think they're justifiable requests, and I am cautiously optimistic that they will be well received by the legislature. And again, Mr. Chairman, happy Renata is here, and I'm here to answer any questions that haven't been answered.
Commissioners, have at it.
Mr. Chair,
Yes.
I think as we go forward and start discussing the needs of the agency, I think it'd be helpful to maybe have a list of talking points that details some of the issues that we're experiencing that are budget related. We already spoke about that, but I just think it would be good to put that down on paper. The backlog, in our rulemakings, for example, the lack of technical advisory services or staff resources on the commission side, on the advisory side, just to name a few. But I think that would help. That way we're all kind of speaking from the same consistent list of talking points regarding our needs.
I agree completely. And actually, I've got this little back of the envelope deal where I started listing things that we need to do, rulemakings and such, just to catch up with recent legislation that we haven't been able to get to. And what I thought I would do along those lines, if the rest of the commission is amenable, is I would just make this list of items that we need to catch up on, circulate it to all of you for you to add or amend to, and that we should pass it on to Wayne so that he and all of us have kind of a complete list. And from there we can just kind of put it into the kind of document you're talking about, Joe, that we can, all talk from when we're talking to the legislature. So I'll just, do other commissioners feel amenable to that process?
I think that's a really good idea, Mr. Chair. I concur. I think it's a good idea to circulate it. I think it's really important when Wayne or anybody goes before an interim committee that we know what we're talking about and we have the details at our fingertips. So the more information, the better.
It's a pretty overwhelming list, by the way. I mean, I think it really strengthens the argument.
They were just working, yeah. Now it's not, my speaker's not even working.
Christopher, we can hear you now, Christopher.
Sorry, Commissioner.
Okay, thanks.
Mr. Chair, and then I guess just one last comment. I think there's the other talking points to be prepared for potential, let's say, assertive questions. I know that this agency's had like a spotty record of budget reversions. And I think that we should at least go back maybe 3 years, at least 3 to 5 years, to see what our track record has been with respect to budget reversions, to be able to address those. And so I think we should be prepared. And then we should also maybe look at our vacancy rates historically along with budget reversions and try and remind legislators what the situation has been, to try and explain perhaps unusually high vacancy rates or major budget reversions. And I think we should even have in hand a projected end of year balance for this last fiscal year. I know we haven't had kind of a closeout briefing yet, but I think that we should get a handle on the reconciliation of any prior year encumbrances in this last fiscal year and see if we can come up with a number. And hopefully, if it is a reversion, it's not too large. So I'm just saying, let's be prepared, for those kinds of questions. That's all I had, Mr. Chair.
Thank you. Other commissioners?
I concur. I know that certainly vacancy rates has always been something that was something that I know Jason Montoya said he was, he had to explain, but he was glad to explain because, we weren't provided enough funding to offer adequate salaries. So that was, that is a big reason why we can't fill positions, because our salaries aren't competitive. So that leads to a good talking point, but it is, it's an unfortunate metric if somebody doesn't know the background. So we have to explain it.
Okay. Other commissioner thoughts, comments?
Oh, Chairman Fishman.
Commissioner Byrd.
I agree. I've been proposing more than 3 years, as Commissioner Mastis mentioned, but I think going back a few years just for the historical perspective is good. And I agree with what everything else that has been said. Well, maybe not everything.
We know you.
Yeah, you don't want to be too easy. We get it. Other commissioner comments? Okay, one other thing I'm thinking, just as we're talking, when I send this memo around, is that it would probably be helpful to Wayne if we each listed legislators on the appropriate committees that we might be talking to, so that Wayne has a sense of, who's been communicated with. And when I send this kind of straw memo around for you all to amend, I'll include a list of all the appropriate committee members, and each of us might note on that who we feel comfortable talking to in support of doing this budget. Would that be helpful, Wayne? And would you ask for anything else you'd like included there to help you out?
Mr. Chairman, first of all, I think that list is great, and all the other suggestions for talking points, we'll get those. And once we get your list, we'll turn around a draft for the commission very quickly. Absolutely, Mr. Chairman, and particularly as we get closer to the session, communication amongst all of us and who we're talking to and what we're hearing, intelligence at the legislature is worth its weight in gold. And so if you're hearing something and can pass it along, and I will do the same. But yes, now is the time to put together a list of our friends that we can reach out to and begin that process. So thank you for that suggestion.
Okay.
So, Mr. Chair, I got a question for Wayne.
Sure.
So, Wayne, I just noticed that you just said as we get closer to the session, but I thought with interim committees, our real objective is to get to them not close to the session, in the interim when, they're not so pressed by other people who want their attention. Wouldn't it be better for us to be communicating sooner rather than later to them about anything we want to talk about?
Mr. Chairman and Commissioner Hall, that's a great point. When I say getting close to the session, I mean today. I believe
okay.
I consider us to be close to the session today.
Yeah, that's
Once
kind of how I
these are
feel.
approved. Absolutely.
Good. Thank you very much.
Okay. Any other discussion? Renata, you didn't get to speak, but thank you for sitting in. Okay. I guess we're ready to move on unless commissioners have any other thoughts or questions.
Mr. Chair, I just have one question of Wayne also. Wayne, you mentioned there were a couple of interim committees and then I forget the other committee, not an interim committee. Maybe it was LFC. I don't know, but what are the interim committees that you're anticipating going to between now and the session?
Water and natural resources, Mr. Chair, Commissioner Hall, and members of the commission, water and natural resources in October, the Legislative Finance Committee in November, and also because this is a 30-day session, the House Appropriations and Finance Committee will begin meeting before the session, so that will be the first session committee that we will appear before. So I anticipate we'll have at least 3. It's possible we could appear before the Senate Finance Committee before the session begins as well. But I anticipate we'll have 3 to 4 opportunities to discuss our budget with committees prior to the session actually beginning.
Okay, great.
And Mr. Chairman, we were hoping that the commission would actually vote to approve these requests so that I can say that in front of these committees.
Okay,
Mr. Chair,
yes,
we'll move to approve the the potential FY 22 and 23 supplemental budget adjustment authority and supplemental appropriations request.
Second.
Mr. Chair, just under discussion too, I think we've already had a discussion among the community solar group, but we are already working on putting together a community solar implementation budget. And so I think that's got to be done hopefully no later than mid-October. And it's going to be kind of a pre-community solar final rule budget. In other words, what do we need from now until April 1st? And then we're going to come up with the second part of our community solar budget needs assessment from April 1 until June 30 of 2022. So that's going to be under development, together with talking points regarding our needs and so forth. So I just want to make sure that continues to progress.
So, Mr. Chair, I have a thought about that. That seemed like a really good thing to do, to have a budget associated with each specific effort. Of course, community solar is a little different from our other rulemakings insofar as it's, a new statute, and we're directed to have the rule done by a date certain. But, to the extent that we have costs associated with other of our projects, such as the interconnection rule or the IRP rule. In the past, I don't think we've ever really enumerated what the costs are if we've had to go get extraordinary costs, like a DOE staff member for 2 years, DOE, adjunct to our staff. But I wonder if it wouldn't be something to explore to explain the extraordinary steps we've had to take to beef up our staff and the cost savings it represents, and also to explain the costs that go into these processes, like a workshop process that takes a long period of time and involves a lot of our staff time. So it's just a thought. I wanted to put that out there if anybody else had any reactions. I know Commissioner Maestas is really good about showing our costs. And I don't know if you or any of the other commissioners or even Wayne has a reaction, or Renata, to that. I don't want to generate a bunch of, additional work for something that wouldn't need to be dealt at such a granular level. But I know in the past when I've talked to members of the legislature, I don't have numbers associated with each effort, and I don't know how much that would impress them anyway. But it's just a question, an idea I wanted to toss out there to see what other people thought.
I guess my initial reaction, Commissioner Hall, is that it's the community solar is a little bit unique
Yeah,
in
I
that
know.
there's a
like it.
very discrete kind of workload that we can identify that will be generated by it. Whereas many of the other rules are really just, well, I shouldn't say just, but are really just modifications to ongoing work of the agency. And I don't know if it'll be,
True.
I don't know if it'll be nearly as clear about the additive, other than to say, gee, you know, here's all this stuff we have to do, and we don't have the staff to do it. And this is the backlog that results. So I think it might be more confusing than helpful
Yeah,
to make cost budgets on those kind of items where it's much more difficult to tease out individual costs. Joe, what's your thought on that?
I mean, I support, you know, Commissioner Hall's request. I think it's always good because we're going to get asked. I mean, I think we're going to get called on the carpet. You make a budget request, you know, what's it for? And, you know, legislators aren't going to want to hear the details, but I think perhaps their staff or their office wants to see the details. In fact, you know, we may even have to submit this in advance of any kind of hearing before a committee or even a meeting with an individual legislator, because they're going to want to see the details. Anyway, that's my take on it.
What would be your specific recommendation about how we proceed on that? I'm still a little unclear.
I'm kind of agnostic on it. You know, I think I'll defer to Wayne. I think Wayne is, you know, been having a lot of discussions with legislators, and he's, you know, we've already met with DFA, which I think is strategically the right thing to do to kind of prepare them, you know, for our request. And so I don't want to suggest something that's maybe contrary to how these discussions are going. And certainly, you know, I don't want to complicate the issue either, because we can, you know, if we start conflicting, you know, if we start putting forth justifications that are conflicting, we could shoot ourselves in the foot. And so, you know, maybe this is going to be an incremental approach, but I know at some point we're going to be called on to provide details on, you know, budget needs, symptomatic general needs from lack of budget.
Mr. Chairman, I guess my suggestion would be, I think this sort of ties into the list that you're preparing. So let's get that list together. We know there's specific needs related to the Community Solar Act, but once we have that list, perhaps we can have a discussion about it and kind of wrap in Commissioner Hall's suggestion where we see other items that we may be able to tie specific needs to. That would be my suggestion at this time.
Okay, that sounds fine to me. Any other thoughts? Go ahead.
Thank you, Mr. Chair, and Wayne and Joe and Commissioner Maestas. I appreciate that. I think going forward, you know, it's just important to illustrate, I think, the concept that we have a workload that requires a certain amount of work, and we have a certain amount of staff, and we're, at least I know I have been pretty constantly, it feels like, trying to find ways that we can augment our staff with either free or not very expensive additional help. And if we can show a set of costs, a set of items and their associated costs with each rulemaking or other project we're pursuing, and then explain that how many of them require additional services. I think it can only be helpful. And if the committee itself is not the right audience and their staff people are the right audience, then we should go to them. But somebody ought to know our whole story and what we're trying to do as well. And the fact that we make continued efforts to try to bootstrap, freebies into our workforce, basically. So,
So Commissioner Hall, I will, in this, straw draft that I send around, I'll try and include a few of those kinds of items that you just talked about, things that we've done and been doing.
yeah, good. I will too.
And that'll, help flesh out the story for Wayne,
Yeah.
who's going to be the point guy who's doing a lot of the selling here. So we need to give him all the ammunition we can. So great suggestion.
Mr. Chair, I think just another, in lieu of costs, I think maybe if we paint the picture in terms of the duration of some of these things, because what I've come to hear from everyone is that, for example, a rulemaking from beginning to end can take up to 18 months.
Mhm.
And so if we, by listing all the rules that we have backlogged, and then you compound it with the timetable to develop a rule from beginning to end, I think also paints a picture of how intensive some of the things that we do here in this agency. So, certainly in lieu of costs, I think, putting average duration of rules, I think will help. And I think, Mr. Chairman, you've been stating repeatedly that because of our lack of technical advisory services, we rely on interveners, whether it's a modeling run or proficiency in software, even verifying software and data runs by investor-owned utilities, for example, in their integrated resource plan. So I think that's another talking point that's powerful, where we literally have to rely on the expertise of interveners many times, and that shouldn't be the case.
So thank you, and I will outline not just the duration. When I send this initial draft around, I'll outline some of the due process requirements that lead to it taking a long time, and that create a lot of the work. You have to take a lot of input and sort through it, and be sure that everyone has a chance to make their final arguments on any piece of evidence that's brought forward. And I know it's a rulemaking as opposed to a docket, as opposed to a adjudicatory docket, but a lot of the same issues apply. And I think outlining that process to folks might help them understand the challenges, why it's not just you snap your fingers and it's done, particularly with the number of stakeholders involved. So I will try to outline those issues as well in this initial note that I send around. And again, feel free to modify or add to it. I'm just kind of throwing out a first group of thoughts.
Mr. Chair, too, I think it's commission practice to engage in pre-rulemaking workshops, using more informal coordination with stakeholders, and oftentimes, at least my limited experience with it tells me that the pre-rulemaking extra effort, which isn't called for, I think, in any rules or statutes, we do that of our own volition to give stakeholders a seat at the table, to have a robust discussion about what should go into a rule. And so I haven't heard any complaints about the workshop process, the pre-rulemaking workshop process. And I think it's a good process, but it is resource intensive. And so I think we ought to mention that as well in the way we do business and to articulate kind of the needs that we have. Thank you.
Okay.
Mr. Chair, I would like to echo those remarks as well. And I was just thinking of that as you were talking, because that is something that, even though it's labor intensive, we have stepped up to try to do, at least in one rulemaking so far, well, several rulemakings now, interconnection and community solar. And it's very demanding. I mean, I think it's a much more engaged way to deal with the public. And sometimes it bears fruit and sometimes it doesn't. And that can be frustrating, but at least we have tried to give everybody a voice and a seat at a table in a way that, seeks consensus. So, I just think it's a practice of good government. But on the other hand, we are sometimes time limited with, for example, the community solar rulemaking. And so I think that is something that, that's just, I guess, comes with the territory, but it is something that should be noted somewhere, that we're trying to do the best job we can with resources that probably really aren't up to the job, but we're trying in any case.
Okay. And, I know in our recent telecom rulemakings that I'm sure Commissioner Vicente Aguilar probably agrees with just about everything we've said here. Correct, Commissioner?
Yes, Mr. Chairman. Good morning, everyone. I'd like to applaud our Chief of Staff, Wayne, and also Renata. And I think they have a clear understanding of how they're going to communicate with the legislature within the coming months. And so I have faith in them. I believe in them. I will walk with them. Renata was straightforward as far as the special services, the budgets for contractual services. She said, we only have this much. And that is all we have. She's speaking solid according to the numbers that we have in the budget. So for that, that's just an example. And so that's the reason why I support our staff on this particular issue. Thank you.
Okay, thank you. Any other comments before we move on? Okay, Wayne, Renata, thank you very much.
Mr. Chair, I think we need to vote.
Oh, I'm sorry. Yeah, I keep skipping over that. We've got, lacking further discussion, Mike, please take the roll.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas.
Aye.
Commissioners, the vote passes 5-0.
Thank you, Mr. Chairman.
Thank you. Consideration and approval of prior meeting minutes.
So moved.
I'll second.
Second.
Commissioner Byrd, for the record, did the second. And if there's no further discussion, Mike, please take the roll.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd.
Aye.
Commissioner, the minutes for the September 8th, 2021 meeting are approved by a vote of 5-0.
Okay. And Mike, could you quick read through and the consent action items that are up for consideration?
Sorry, I'm just trying to get these on my page here. The consent action items are cases, transportation matters, case 18-00140 TRM in the matter of the application of Superior Ambulance Inc. Service Inc. for a variance of Motor Carrier Rule 18.3.1.10C NMAC pertaining to stationing points. It's a proposed order, potential order, and case 21-00155 TRM in the matter of the application of Running Bear Rescue Inc. DBA Rocky Mountain EMS for reissuance of certificate number 43374 to provide ambulance service. This also is a potential order. There are no utility matters. I will take the roll. Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman.
Aye.
Commissioner Hall.
Aye.
Commissioners, the consent action items are approved by a vote of 5-0.
Okay, on to regular action items. Utility matters number 419-168 UT and the matter of the petition to amend the energy efficiency rule, potential final order. Hans, please lead us through it.
Thank you. Good morning, Chairman Fishman and Commissioners. The proposed order before you recommends the amended language for adoption based upon comments received during the notice period and public hearing remarks. Proposed order also sets a deadline for a staff petition for further proceedings as a second phase for matters that won't be addressed at this time during this rulemaking process for this order. Just to do the quick background, on March 24th, 2021, the Commission issued the order initiating proposed rulemaking and notice of proposed rulemaking to bring the energy efficiency rule into conformance with the 2019 amendments to the Efficient Use of Energy Act. Initial comments were received by the Coalition for Affordable Clean Energy, New Mexico Gas Company, SPS, Utility Division staff, and joint comments by EPE and PNM. Response comments then were received by CCAE, SPS, New Mexico Gas Company, New Mexico Affordable Reliable Energy Alliance, Utility Division staff, and again, joint response comments by EPE and PNM. A public hearing on the matter was then held on June 21st, 2021. The areas of concern raised from the comments can be summarized into 5 subjects. Number 1, life safety code violations. Number 2, removal of regulatory disincentives. Number 3, removal of the cap on performance incentives. Number 4, requiring coordination with community resources and utility coordination. And 5, provide flexibility for modification of programs. I will address each in short summary fashion. The life safety code violations, which is language pertinent to section 17.7.2.9. B3 was inserted into the proposed language in the NOPRA. However, EPE and PNM recommended striking the language. Upon review, Utility Division staff stated they understood the implications that this would impose on the utilities and that this section would implement, and agreed that with PNM that the language should be struck at this time and developed and discussed more in a further rulemaking proceeding. The removal of the regulatory disincentives, which is language on section 17.7.2.17, that was removed in the NOPRA, and EPE and PNM indicated that this section should at least repeat the statutory provisions. New Mexico Gas Company believed a workshop should be used. Staff indicated this section is not ripe for rulemaking at this time, as outstanding issues exist in case number 20-212 UT regarding decoupling that would affect this section, and indicates this is appropriate for a rulemaking proceeding upon resolution of the issues in that case, and thus should be struck at this time and developed in a further rulemaking. Removal of the cap on performance incentives. Regarding the language of 17.7.2.8L, CCAE proposed new language striking the cap on performance incentives to give utilities incentives to exceed the minimum savings by statute. Staff reviewed and indicated that no change in the amended statute would impact the capping of performance incentives, and thus this is beyond the scope of the NOPRA to bring it into compliance with the 2019 amendments. They also noted the cap has been in place for many years and developed following challenges to an earlier version of the rule, including a Supreme Court appeal. My proposed order then would not adopt the proposed language and set this issue of performance incentives for a future rulemaking proceeding. Requiring coordination with community resources and utility coordination. This is for section 17.7.2.8. CCAE proposed new language requiring utilities to coordinate their programs with existing community programs. Staff reviewed and feels this also is beyond the scope of the NOPRA and notes that case number 21-112-UT, the community solar rule, will provide some building blocks for low-income participation, and this section can best be addressed at a full future rulemaking to address this concern. And providing flexibility for modification of the programs. This is in regards to section 17.7.2.12. CCAE proposed language to allow for the transfer of funding between programs for the purpose of improving the overall kilowatt savings of the programs. EPE and PNM indicated they were not opposed to the proposed language by CCAE. Staff reviewed and indicated they believe the proposed new language is not necessary to make the new rule consistent with the amended rule, but makes no objection to the insertion of the language. My order then would adopt CCAE's language for purposes of improving the overall savings of the programs. My proposed order then adopts the amended proposed changes, sets the amended rule for publication, authorizes the Office of General Counsel to make any formatting and proofreading changes necessary during publication, and sets the unresolved issues from the above for a future rulemaking to be initiated by staff petition no later than 45 days after the final order is issued in case number 20-212 UT. Further, the staff is ordered to file a status update into this docket no later than March 1st, 2022, regarding whether they have filed the staff petition for the future rulemakings. And if the petition has not been filed by March 1st, 2022, staff is required to continue those status updates in 6-month intervals until the petition has been filed. So in a nutshell, we are taking steps now, the necessary steps now to bring it into conformance with the 2019 amendments. And we have identified a handful of issues that we feel should be addressed as well, but those are not quite ripe at this time under this NOPRA for rulemaking. But with the order, I say we're keeping this kind of on a tight leash for the second phase. And telling all the commenters that we are interested in making further changes, but you don't always get to jump to the top of the ladder. Sometimes you do it rung by rung. But so this effectively, in my opinion, commissioners, gets us through those first couple of rungs of this ladder to bring it into conformance, as well as letting interested parties know that we are still going to be addressing the other issues that were raised in a timely fashion. So with that, I will note, commissioners, after talking with Commissioner Fishman, I did send out an email yesterday around 4 o'clock. The initial order that I had circulated I did make some changes to the decretal paragraphs, and that email highlighted those changes that were made. Simply for clarification. And we added one extra paragraph ordering that staff, as a part of the second phase of the review and submit proposed language as to whether the awarded incentive should be capped at annual net customer dollar savings from the program in any given year, and or whether exceeding energy savings and net cost goals should factor into the determination of incentives. So just another area that was brought to my attention that we definitely want to take a look at during the second phase of this. I just wanted to bring that to your attention. So that is the proposed order before the commission right now, and I'll stand for any questions.
Commissioners, questions, comments?
Mr. Chair.
Yes.
So I read the final order first, and then I saw the email about the revisions. And I have to say, in paragraph E, I thought Hans's original language was more clear. And I wanted to ask, why did you want to use the language including but not limited to? And then we list 1, 2, 3, 4 items, and there are 5 that he mentioned. Life safety code violations, regulatory disincentives, caps, and coordination with community resources shall be initiated by staff petition for a future rulemaking as a second phase. The first thing I thought was, well, wait a minute, what did I miss? And there is the 5th item.
The fifth item is
Did you use that language in order to leave out the 5th item? I'm sorry, did you use that language in order to leave out the 5th item on purpose? Is that what was the purpose here?
Well, the fifth item, the flexibility is actually being adopted at this time. So there won't be any reason to revisit that.
Okay, but then why do we say including but not limited to? Because it is limited to then the other 4, right? Why don't we just say the unresolved issues that should be set for future rulemaking are, and then list those remaining 4.
I don't want to limit it just to those 4, because as Commissioner Fishman had discussed the question regarding what I inserted into paragraph F as another discussion. So while I wanted to clarify which of the 4 issues from above are moving on to the second phase, I didn't want to specifically limit it to those 4, since there could be other topics that arise during the workshop and the request for staff to review what is listed in paragraph F. So I think that's why I used that wording. But I would be amenable.
Okay.
I would be amenable to any other suggestions.
Okay. No, I think it's fine. It's fine. I'm satisfied, Mr. Chair. It's fine. And thank you, Hans.
No problem.
Other commissioner discussion?
Mr. Chair, I guess I also was wondering, the last sentence says, that was added, says, if the petition has not been filed, let me see. Well, the whole paragraph G, staff shall file a status update no later than March 1. to update the commission as to whether the petition initiating the rulemakings has been filed and indicate reasons why not, if the petition hasn't been filed. And then the last sentence says, if it hasn't been filed, they'll provide status updates. I guess that's just in recognition of the fact that staff has a lot on their plate, right? And they might not get to it.
That's correct. That's correct. And while I would hope that the decoupling case is 6 months, I can't be positive of that. So just in case it takes longer than, I just wanted to make sure staff just doesn't file the one status update and it drops off. So if it continues beyond that point, get status updates filed into this docket so we know when it's appropriate to close this portion of the docket at least.
Super. Okay, great. Thanks very much, Hans, and thank you, Mr. Chair.
Yeah, and I would point out that we've got the current docket on decoupling with PNM, but what comes out of that docket might suggest that we need to do a rulemaking. So there might even be another step.
Yep.
So, we just need to be aware of that.
Yes.
Agreed.
So with that, do I have a motion?
Mr. Chair, I'll move the order.
Second,
Okay.
under discussion, Mr. Chair, just I wanted to make a few remarks on this.
Sure.
I want to commend Hans for bringing this rulemaking home. It's been pending since 2019. And I have an appeal to all of my colleagues on the commission. I think you've heard me talk about weatherization deferrals. In other words, when homes or applicants apply for weatherization, they have more fundamental life safety code issues that precludes them from receiving weatherization benefits. Right now in New Mexico, through the Mortgage Finance Authority, the program has a weatherization deferral program, but the program does not rectify the issues regarding the deferral. Issues like, electrical issues, roof repairs, asbestos, mold, and so on. And the state of Michigan has a real robust weatherization program that includes an element to correct those issues that precludes applicants from weatherization. And I think it's time for New Mexico, given our high, low to moderate income populations, given the fact that we have very old housing stock, that we introduce that new component to pave the way for weatherization in these homes that have these life safety code violations. Because right now we're just saying, oops, we can't weatherize your home, we're moving on. And there's no rectification of it. So just to give you an idea, the state of Michigan spends over 23 million on weatherization. About 2,500 homes a year are weatherized, but about 830 applicants are deferred. And half of those, which is about a fifth of the total homes, are actually provided funding to address these life safety code violations. So I really think it's past due that we include this element for funding for weatherization deferrals. That's all I had, Mr. Chair. I'm off the soapbox.
Hans, I agree. Is this something that we can address in a rulemaking, or do you feel this is something that's requires a legislative solution, or is it a combo of both, Hans?
I would say it's a combination of both. We definitely had some building blocks, that I think will be able to help into the workshop factor of this. But I know there was a lot of resistance from the utility companies insofar as where does their duty end? You know, it ends meter, and beyond that, they question, you know, what do they really have a duty to report? So while we could make recommendations, I think there would have to be some legislation involved to better enforce that as well. But there is some common ground to be had. But I think there is an understanding that it would provide a benefit, but I think that this would really have enforcement on this would require both, would be
Yeah.
just my top of the hat
Okay.
analysis.
And I thought the utilities put forward rational arguments. It wasn't
Yes.
just, I didn't think it was just obstructionism. They have legal issues, they have expertise issues that need to be resolved to be sure they're not on the hook for mistakes. You know, I would like to see us work that issue further and you know, pursue all levels of resolution, because it's a shame to have these programs in place and then not be able to use them on behalf of the very people who need them the most in terms of energy efficiency. One other thing that I'd note is that you know, we have this 5% low income requirement, and probably 40% of the customers qualify for low income. And at 5%, we're really still falling into the trap of putting our resources not to the people who most need them, but to other folks who are much better off. And that over time, we should be looking at that, because, you know, inadvertently, we're feeding the wealth gap. I don't know how else to put it. But we need to find a way to set aside more money for low income, I feel. So with that, we've got a motion and a second. Any further discussion? Okay, Mike, please take the roll.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Sorry, I was muted. Aye.
Commissioner Fishman.
Aye.
The order passes by a vote of 5-0.
Thank you, Hans, for the good work.
Thank you, Commissioner.
Okay, we're on to item 5, 21-190 UT, Renewable Energy Industries Association formal complaint against PNM, SPS, and EPE regarding utility notices of processing of community solar interconnection requests. Potential order regarding motion for rehearing. And Russell, this is yours.
Yes, Mr. Chairman, Commissioners, good morning. Can you hear me?
Yeah.
Okay. So this matter comes back before the Commission on a motion for rehearing filed by the three respondents or defendants in this matter, who are SPS, EPE, and PNM, the three electric utilities, three investor-owned utilities, electric utilities in a state. Just as a very brief recap of the background facts, this arises out of the Commission's issuance of an order requiring the three IOUs to issue a notice to their applicants for interconnection of community solar projects. So these are interconnection applications having to do with community solar projects. That notice was made 2 points, and this was to be provided to applicants, future applicants, and potential applicants. And the 2 points were, I'm just going to paraphrase. One, that the interconnection rules and interconnection manual that are currently in place remain in place until remain effective and in place until amended or withdrawn or repealed, excuse me. And the second point was that any applications for interconnection of a community solar project that are currently pending or will be pending before at any time before the Community Solar Act rulemaking is finished by the commission will not receive any priority over any other interconnection applications for community solar because essentially the Community Solar Act rulemaking is so comprehensive that that any queues that are being maintained by the IOUs right at this moment, the applications will almost certainly not be completely compliant with whatever rules are to be adopted due to the complexity. So those were the 2 points that were to be made, and there's specific language in the order as to what should be in those notices. And the 3 IOUs were also instructed to work with staff on the form of the notice and how best to get the notice to applicants, potential applicants, and future applicants. So that was all in docket number 21-112, which is the community solar rulemaking docket. And this docket came about, the present docket 21-190, as a complaint by the Renewable Energy Industries Association, which is an association representing, I believe, 20-something developers of community solar projects, who had 3 allegations with regard to the notices actually issued by the IOUs, all having to do with the fact that the IOUs included in their notices additional language. They included the first point and second point word for word as per the commission's instruction. Then they included other language saying that they intended to not accept any interconnection applications for community solar until there are community solar rules in place. So that became the source of this controversy that was raised by the complaint of REIA. And as I said, they had 3 REIA alleged in their complaint that there were 3 ways and 3 violations that came about due to the notice. The additional language provided in the notice. First, that it violated the commission's order, the June 15th order in 21-112, which was the order that defined what should be in the notice. Second, that REA alleged that the IOUs had violated Rule 568, which is the commission's interconnection rule, by stating that they wouldn't accept interconnection applications that would include even ones that comply with the interconnection rules and the interconnection manual. And the third allegation was that the additional language violated federal regulations regarding PURPA, the federal statute. I'm not even sure. I don't know if I even recall what PURPA stands for anymore, the acronym, but that's the federal statute that requires, in certain instances, requires that electric utilities connect with quote unquote qualifying facilities. So those are the 3 allegations that were made in the complaint that all had to do with, of course, the additional language that was included by the IOUs in their notices. The commission, after the complaint was filed, it was served upon the IOUs as our general practice and with a notice of complaint and opportunity for answer. And what was received next was a notice of satisfaction under the commission's rules of procedure for complaints, for formal complaints, which is basically a settlement procedure that that allows the parties to notify the commission that they have agreed to a particular settlement, that both sides will be pleased with this if the commission is pleased with it. So that was considered by the commission a few weeks ago. I don't remember exactly the date of the order. I have to look at my motion, but the commission decided to accept that satisfaction and issued an order dismissing the complaint as satisfied. And in that order, the commission noted that the commission was adopting and accepting the notice of the satisfaction agreement, not just because the parties had entered into it, but because this complaint is completely a complaint that's completely concerned with public interest issues and not private, not purely private interests of the complainant, that it was not being accepted just because REIA had accepted it. And the point I'm making there is that in an ordinary complaint case that is purely private in nature, essentially, if the complainant is satisfied, for instance, if the complainant had a metering issue, an issue that was specific to the complainant, like a metering issue or billing issue, and they entered into a settlement with the utility, that would still have to be something that's accepted by the commission, but it would be accepted generally as if the complainant is satisfied, that's what matters, because there really aren't any larger public interest issues at issue here. Because this was purely a public interest issue, even though the members of REIA as developers of community solar facilities may have a special, more focused interest than the public at large, and even than people who are specifically interested in community solar, it's still the outcome vindicated the public interest, because what they agreed to was a changed and corrected notice that no longer stated that the utilities would not accept interconnection applications for community solar projects. And of course, as in any settlement, part of that, part of the settlement was that there were no findings, there were to be no findings of violations. The commission accepted the satisfaction, but noted in the order that the notices actually did violate the June 15th order. And that was stated as the reason for saying that was for clarification purposes about the scope of the order. But the commission refrained from making any findings with regard to the alleged Rule 568 violation or the alleged federal purple regulation violations. So shortly thereafter, we received the motion for rehearing from the three IOUs, making a number of arguments. But the argument, I'm just going to skip right to the argument that I found compelling, and that's led to this proposed order, which would partially grant the motion for rehearing. And that is that the commission, in accepting the satisfaction agreement of the parties, wasn't at liberty to take one of the three violations that had been essentially bargained away and make a finding of that violation, because it violates the agreement between the two parties that the commission accepted as the satisfaction of the complaint. So it would be inconsistent. And what I've done in the order, though, is to note that when issues like this are raised by a private complaint, issues of the public interest, it's not necessarily a problem that they be raised by a public complaint. by private complaint. Sometimes that's the only way it is raised, and or the only someone that's how someone raises it outside of the context of a rate case or something like that. But the language of this order says, basically for future reference, for future potential, complainants who are considering filing a complaint like this, that's purely a public interest complaint, or for future reference for the commission. These procedures that have been created for private complaints, including the satisfaction procedure that allows the complainant to decide whether the complainant is satisfied with the terms of an agreement, aren't always the best, aren't always appropriate for use in a case that involves completely the public interest. I think I drafted the order this way because I felt that the commission would still feel that even taking out the violation, finding a violation of the June 15th order, that just following the satisfaction agreement would be the best way to go forward. That's the decision of the commission. The commission could deny the motion for rehearing, we could have a challenge by the parties. Their satisfaction agreement might fall apart. Then they might withdraw it and say, well, let's go for a full proceeding, whether it's before a hearing examiner or before the commission. But my feeling was that the commission would rather preserve the satisfaction agreement and just partially grant this motion to allow the commission to fully recognize the satisfaction as entirely controlling the outcome. And I think the commission, as the commission talked about when the commission issued that order dismissing the complaint, the satisfaction agreement contains a notice with notice language that is very helpful, detailed, and clear in understanding the implications and of the commission of the 2 points that I described at the beginning of this little speech of mine about how will that work during the pendency of the community solar rulemaking. So it seems like a good outcome that's been agreed to, and it avoids the need for further proceedings. So that's why I've drafted this order. The other issue that is raised in the motion for rehearing, that is a separate issue that I felt had to be actually addressed in this order, is there's an argument made by the three RUs against the commission's taking of administrative notice in the commission's order dismissing the complaint. The IOUs say that taking administrative notice was improper because the movements were denied an opportunity to make appropriate objections to that administrative notice, which would be in violation of Commission Rule of Procedure concerning administrative notice. The documents of which administrative notice were taken in that order and the order dismissing the complaint were, it was phrased this way. The commission took administrative notice of all records in docket 21-112, that's the Community Solar Act rulemaking, that are referenced in the complaint. And ordinarily documents, there wouldn't be. I mean, there are many reasons for administrative notice to be taken, but here the particular reason was because the order and the notice at issue are in a separate docket from this, and that's because, of course, they were both filed in the rulemaking, and then any adjudication that had to come about couldn't take place in that rulemaking because they're entirely separate procedural issues and ex parte communication issues that arise an adjudication. So that's why in the adjudication, the commission really had to take administrative notice of those records. The response in this proposed order to the argument that the respondents were not given a chance to make objections is that the motion for rehearing process provides an opportunity for making objections to administrative notice taken in the final order of the commission. And in this case, the motion for rehearing does not take the opportunity to actually describe what the respondents' objections, what their substantive objections to the particular records would have been. So they've lost that opportunity. And this has been how issues like this have been treated in the past when it comes to final orders. And the language of this order addresses the fact that it's not uncommon for the commission to take administrative notice of records in another docket in a final order. And particularly in cases like these, complaint cases that are not assigned to a hearing examiner. And the reason for that is often the final order is the only order that the commission enters in these types of cases. These tend to have, if they don't go to a hearing examiner, that usually means they have a lower level of procedure, fewer procedural steps are taken because they're not found necessary. So there's only one opportunity in which the commission can take administrative notice, and that's in the final order. But the motion for rehearing process, allows for any objections, any types of objections to the final order. So there's no reason it can't be used for an objection to administrative notice. I believe it has in the past. I can't think of any particular instances, but it's often used for evidentiary objections as far as I can remember. But so there's really no reason for the IOUs to have not taken this opportunity to actually make specific objections. And of course, it's difficult to imagine what those objections would have been, given that the commission was taking administrative notice of just those documents that are cited in the complaint that happened to be in the rulemaking docket. So that is the part of the motion for rehearing that would be denied. And again, I felt that this portion of the motion had to be addressed, specifically addressed in this order, even though procedural objections and evidentiary objections are usually mooted out by granting the substantive relief that the movement sought. In other words, because this order grants the motion for rehearing to the extent that it removes the finding of violation, that's the substantive end that was sought by the IOUs. All of their other arguments about how the procedure reaching the violation, finding a violation, those become moot. But the administrative notice issue was separately stated in the motion. There was specific language identified by the IOUs that they would have removed from the order if the rehearing motion were granted on the administrative notice issue. And like I said, I felt this was an opportunity to describe why administrative notice is often taken in a final order, because as I said, it's not an unusual practice to do so. With that, I'll take any questions.
Commissioners.
Mr. Chair, I'd move the order.
I second. Any further discussion? Okay, Mike, please take the roll.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Whew, aye.
Order is approved by a vote of 5-0.
So Russell, you could have convinced us probably with a lot fewer words, just for future.
I felt I was being a little long-winded, but I didn't know how to stop myself this morning.
Just for future reference.
Yes, I understand. I apologize for that.
It's fine. It's fine.
Yeah, don't worry about it. We're on to item 21-212 UT. And the matter of the Commission's annual report to the legislature regarding status of the State Rural Universal Service Fund as per section 63-9H-6Q of the Rural Telecommunications Act of New Mexico. Potential final order adopting report. Russell, again, it's you.
Okay, I'll be very brief with this because this is the report that I provided to the commission. The version I provided one version on Friday, but there was additional material that was completed over the weekend and added to the report, which I provided to the commission by email on Monday, which had my track changes and 2 exhibits that have been at the first one of which you already exhibit A commission already had. That was the 2019 reports of the legislature regarding the SRUSF. This is what I've labeled as the second report. So the legislature will have right in front of them the initial report, and they'll be reading the new report. So and this report is the second report is meant not to be duplicative of the initial report in any way. Then there was Exhibit B added, which is included the award amounts for all awards that have been made by the commission over the 3 years of 3 complete cycles of applications and granting and denying applications by the commission that identifies those awards by service area, by the amount of the award, and by the carrier, and also by the year. So that's something specifically asked for. At least the award amounts and service area is specifically required by the statute. So that was added. The commission has that. And the table that have been requested by Commissioner Maestas at last week's open meeting, which is the table showing basically a sensitivity analysis showing how sensitive the per connection surcharge that funds the fund, how sensitive it is to changes in the amount of the fund or the size of the fund, looking at how it would affect the cap if going in $1 million increments from 30 million to $35 million. That was added. I added that to the section on the commission's recommendation. And again, that was based on the fact that I'd plugged in a recommendation, assuming some sort of increase in the cap. But as I said multiple times last week in this email, that's entirely up to the commission. And it's a policy issue. And the recommendations that were in the record from the commenters, I believe only one, the New Mexico Attorney General actually recommended increasing the cap. And there were numerous other recommendations made by other carriers, and then by staff recommended not raising it. So again, I just want to reiterate, I just put that in there because it's often easier to have a material in a proposed order that even if you have to completely reverse the position or change it, it's better to start with something than a blank slate. So I think I explained that. So at this point, what the commission needs to do is to agree on any revisions to the report or adopt the report as is, except the one thing that must be changed is that the commission has to actually decide what the recommendation or recommendations will be as to specifically the statute says as to the size, as to whether the cap should be maintained, modified, or removed, I think is how they put it. Let me get it right in front of me, the language. And also changes, any recommendations for changes to the structure, size, and purposes of the fund. So it's wide open for the commission to make recommendations in those areas regarding the fund. And so I will step back and allow the commission to ask questions and discuss any recommendations.
Commissioners,
Mr. Chair,
Commissioner Hall.
I had a number of small, well, first of all, there were a number of typos I thought could be fixed. But then I had several points I wanted to ask Russell about in terms of just how well to phrase certain things and should certain items be explained. And then I wanted to discuss the sensitivity study and in particular, maybe expanding it to get a little bit more information to inform what I think would be a recommendation of mine to expand the size of the fund. But I think it would require even more information than we have right now from that sensitivity study, which I think is a great illustrator. So I'd like to proceed, if I could, with going through the issues I had in the text in terms of items that may be reworded or better explained. And as we're going through, I guess just hit on the typos. And then I'll get into the sensitivity item at the last. Is that okay?
Sure.
Okay, so Russell, on page 2, under Roman numeral 1, paragraph A, where you talk about financial health and administration of the fund.
Mr. Chair, Commissioner Hall, so is this version 2 or version 1 of the report?
This is, oh, well, you know, it's what was attached. It's the second report of the New Mexico Public Regulation Commission to the New Mexico Legislature concerning the State Rural Universal Service Fund.
Commissioner Hall, just to clarify, what did this already have my some track changes on it? Because that was the one from Monday.
It has no track changes showing in it. Is this an older version then? Is that what you're saying?
Well, I can't say that because sometimes that's the fact that no track changes are showing is a function of the settings you have on your Microsoft Word program, because it could include track changes. But you know, I can tell you, I can give you some test as to whether it is the Monday version or the Friday version. The Monday version will have the section 5 that refers to exhibit B, the spreadsheet of award amounts and service areas.
Yes, I have that.
Okay, then you're working with the latest.
Okay. Okay, the second sentence says, the SRUSF continues to be funded by a per communication connection surcharge pursuant to the RTA. And, you know, you mentioned later on, I believe, that these connections are landlines. But I was thinking, wouldn't it be a good idea to maybe mention that up front? Because I remember when I was first learning this statute, I wasn't sure what a per communication connection surcharge was. And if this is a report going to the legislature, there may be some new legislators reading this and may not really grasp that the per communication connection pertains to a landline connection. So I wondered if you could maybe put in some, you know, maybe parenthetical language or something in that sentence to clarify the nature of that connection so they understand what it is.
Well, first of all, Commissioner Hall, it's not the case that the per communication connections, that communication connection only includes landlines.
Okay.
You may be thinking of, with regard to the SRUSF, access lines is something that
Oh, that's what I'm thinking of.
Yeah.
You're right. No, this is fine. Yeah, the per communication connection charges is everybody. It's all anybody with a cell phone, basically, right?
Yeah, cell phone, and even somehow, and this is it's a mystery maybe how this is done, but it includes VoIP numbers. So
Yeah, that's right. Okay.
somehow it's
Sorry.
done as well. So, and I didn't the communication connection that's a communication connection is actually a term that's defined in the statute. And it was discussed in detail in the initial order because we had just changed over to the per connection surcharge then. So
Yeah, you're right.
Address.
Okay, my mistake. I apologize.
Oh, no.
Okay, so then moving on to page 3, the top paragraph. You have a sentence, the second sentence begins, on a monthly basis, the fund administrator collects revenue from all telecom carriers that have communication connections in the state. And then in parentheses, which the carriers pass on to their customers through a charge on each bill. You're referring to the surcharge, aren't you? When you say a charge. So would it be a little clearer to say they pass it on through the aforementioned surcharge on each bill?
Yes, that could be more, is more specific, definitely. Yes, that's the actual surcharge, per connection surcharge. That's what you see on your bill for any number, any phone number that you maintain. So that's a good way to, I think that's a good idea to clarify it there through the aforementioned surcharge.
Okay, let's see. On page 5 of 16, the second full paragraph that starts with true up. There's a sentence at the end of that paragraph that says that obligation will cease at the end of 2021. And so my question is there an effect on the surcharge? Would it go down? And if so, by how much? What's going to be the effect on the surcharge when that obligation ceases at the end of 2021? Do we know?
Well, it will be this, this it will free up $1.8 million annually. So that's a good point that you're pointing out here, because I think I've discussed with the commission previously, what the various factors are in terms of the funding obligations for 2022 and how they will affect what's available for broadband program funding. But I'm not sure they actually mentioned this very large one, the $1.8 million in true-up payments will go away. Although I'm not sure. Yeah, it would. Yes, I believe that that's the case. I'm trying to remember if because these are payments, this wasn't something that necessarily lined up exactly with the calendar year. We probably started making those true-up payments the month after that we received the Supreme Court's decision overturning the commission's decision to impose the 3% cap. So if Mike Ripperger is available, I think he should be on this call. He might be able to tell you whether that really will be a difference of $1.8 million being freed up for next year. I think it is on its face, but I'm not 100% positive. Let me see if he's available. I don't even know if he's on the call. It will have a large effect, probably the $1.8 million, but I just want to make sure I'm not missing something, because those payments would not have started probably would not have started at the beginning of a calendar year. Like all these other obligations are always done by calendar year. This is obviously even the true-up payments here are broken down by calendar year, but I'm not sure. I just want to make sure that I am correct about that much will be, that full amount of $1.8 million will be, an amount that's freed essentially for use. You may not be on this call. I I neglected to ask him to be available. He usually is available. But I don't see him here. He may have had another obligation. But yes, I think it will be. I think that's a very large amount. That the entire amount will be of 1.8 million will be, that'll be a reduced obligation on the fund in that amount. So that's something I would point out to the commission now, because I'm glad you pointed that out, Commissioner Hall. And then if you want to say something in particular in the report, we can do that as well. I didn't include language in here. Like if we do that, then we should probably also include language about the anticipated change in the access reduction support payments. We don't know exactly what it'll be. Obviously, we don't know because we have a docket pending for the commission's decision on the affordability benchmark rate, which will affect that calculation. But we also don't know what the access lines will be. Well, we have access line information that just came in last week, but it hasn't been tabulated as to what the change is, how it'll affect the size of those payments. So if we're making projections as to how this will be different next year, I would include that as well. I tried to, I think it makes sense that those are important factors in how next year will be different from 2021. But I would say that I tried to keep this section very simple and just describe what the payments are. But, there's no reason we can't also include, a discussion of any predictable or somewhat predictable changes for next year.
Okay, well, that would be fine. That makes sense, I guess. I mean, to the extent that true-up payments would be ceasing at the end of 2021, then yes, please explain how that would make things different for the next year. Yeah.
Okay.
I mean, I'm just trying to put myself in the position of a legislator trying to understand things. And, when I see a sentence like, okay, well, this obligation will cease at the end of 2021, I just wondered then explain the scenario to me going forward from that,
Okay.
Okay. So on page 7 of 16, sort of the bottom of the first paragraph on the page, there's a sentence that begins, as the project would have served an unserved area, and because the commission did grant a number of applications. Do you see that sentence?
I'm sorry, what page was that again?
Page 7. Page 7. About 2/3 of the way down the first paragraph.
Mm-hmm.
The sentence begins, as the project would have served an unserved area. Do you see that?
Yes.
Okay, it goes on to say, and because the commission did grant a number of applications for proposed project that were served.
Yes.
I think you want projects that were to served, underserved areas.
Yes, thank you.
Have some
I was
stuff
planning
out
to do another proofreading of this, but obviously, thank you very much for catching those.
No
I
problem.
apologize for that.
There's a similar correction on page 8 in the bottom paragraph, third line. Let's see, it says, a sentence begins on the first line. First, that multiple prioritization criteria, do you see where I am?
Yes.
Will essentially always come into conflict with each other. So as no set of proposed projects.
I don't have a so in there. I'm using as like because it said because.
Yes, you're right. As no set of proposed projects is likely to fall into the same ranking. I think you want happen to fall, right?
Thank you.
Okay, right. Okay.
Oh, and I have an and in there after standard that I don't need. One prioritization standard as it does under another standard.
Yes, right.
Thank you.
Okay, and then on page 10 and Roman numeral 2, the first, sort of toward the end of the paragraph, let's see, well, the paragraph describes that the commission received comments. Halfway down, it says comments and recommendations were received from the AG's office, the Telecom Bureau, and broadband carriers. Then it says the following recommendation by the commission is not identical to any of those recommendations and is instead based largely upon the commission's experience. You know, the way that reads is, it sounds a bit like, yeah, we got these comments, but we're really just going to rely on our experience. It's a little dismissive sounding. You know, it sounds like we're disregarding the comments in large measure. I wonder if you mean that. I don't know that you do.
Yeah, I do see what you mean. I could include a more detailed discussion or any discussion, a discussion of the content of the comments. And of course, I included this language which may be mooted by any other by any actual recommendation that's adopted by the commission. The commission might actually choose to adopt one of the commenters' recommendations. And so, but I see what you're saying as well. I definitely can just get rid of that for now, and then we'll see what, I think we'll want to know what the commission's decision is with regard to a recommendation before deciding how to change that. Although we could, if you're saying you would like a more detailed discussion of the comments and why the commission.
No, okay. I'm not saying that. I'm just saying, you know, we should acknowledge that we, you know, paid some attention to them somehow, and like our the following, let's see, the following recommendation, you know, I don't know, it takes into account these comments and then is also based on the commission's experience or something like that. You know, it doesn't have to be extensive, but just at least acknowledge that we read them and we take them into account somehow.
Yes, you're right. When you bring up the sentence, I realize it is oddly unbalanced. It doesn't say, you know, even if the commission does not adopt any of the recommendations, that they were read and carefully considered and informed this decision or something. I think
nice. That's nice. Yeah, that sounds good. Great. Okay. Let me see. Okay, on page 14, Roman numeral 4. The first line says the RTA as amended this year by, and then you've got a couple of words mashed together. I think it's above described, but you can see that word, right? Above scribed or subscribed. It's all one word. Yeah. You see where I'm talking about? At the top, the first line under Roman numeral 4, the first paragraph begins, the RTA as amended this year by the above described. It's all one word.
Should be above described, you have an S and there's a D. Yes, thank you.
Yeah. And then let's see. A little bit further down, you have a quote that pertains to, or it's a, you know, an indented paragraph that has that's spelling out subparagraphs G and H, some definitions there.
Yes.
Right below that, there is a sentence that begins, the amended RTA requires the commission to include in its broadband program rules include a requirement that the commission.
Yes, that second include obviously should not be there. Thank you.
Include out, yeah. Okay. On page 15, you have in the top line, there's a sentence that begins, with regard to the OBAE, the Commission's Telecom Bureau staff have been in contact with the personnel within New Mexico DoIT who are working on setting the OBAE for a number of months.
Oh, this resetting up. It was just, you have been working on setting up the OBAE for a number of months.
Okay, great.
Yes,
I
thank
just
you.
wanted to know, what does that mean?
Yeah, that didn't make any sense. I'm sorry.
Okay. So then those are the main things. I had a few issues with commas, but I don't want to take the time here to deal with it. So, so then I'd like to just mention something about the sensitivity analysis. Actually, yeah, let's start with that. I thought it was very illuminating to see the change in the surcharge. It wasn't that great to go from 30 million to 35 million. I mean, it went from 94 cents to $1.12. So that's 16 cents increase, which I don't, I know every penny adds up on the bill, but I don't think that's a huge increase to achieve $5 more million to devote to developing broadband. So I started wondering, what would it look like if, rather than trying to see what it looks like, what the bill impact is if we go up to 35 million, what would the bill impact look like? The surcharge, I should say. What would the surcharge be if we increase the cap on the fund to accommodate all the requests that we got in this year, which amount to a little over $37 million, I think you said in this report. I forget where that is, but it's like 37,020,000 and change. So I just did a little back of the envelope calculation and using the table on page 4, because if you go to the page 4 table.
Commissioner Hall,
Yeah.
sorry to interrupt you, but I think Russell dropped off.
Oh, shoot.
Russell, are you still with us?
Doesn't sound like it, does it?
I
Yeah,
apologize.
I saw him. It
Commissioners,
said he logged out.
Oh, here he is.
I had a little connection problem there.
Okay.
I'm back though. Can you hear me?
Sure can. What was the last thing you heard me say? Because I was going on, and I'll cover it again depending on what you missed.
I think you were just turning to after having gone through the revisions. I think you were turning to discussing recommendations. You would just discuss the surcharge sensitivity analysis, and that
Yes.
that 94 cents to 112 seemed like a fairly small increase in the surcharge to result in $5 million additional $5 million available for the fund.
Correct. Good. You didn't miss too much. So then what I was saying was, I'd be interested to see that sensitivity analysis carried out to a higher amount that would raise the cap sufficient to spend all the money that would be required to pay for all the applications we got this year. And I found the page where that amount is stated in the report. It's on page 9 in the bottom paragraph. On the third line of that paragraph, it's $37,020,771. So I went to the table on page 4, and where it says broadband, $13,844,000, and that green line right about in the middle of the table, I replaced that with 37,020,000, etc. And I got a total figure of it was upwards of $57 million. It was around $57 million. I don't have the exact numbers with me right now, but it's roughly $57 million. So I wondered if the sensitivity analysis could be performed going out to $57 million rather than $35 million, just to see what the surcharge would look like.
Absolutely. There's no reason we couldn't do that. One thing I would note is the table in section 2 is the 2021 fund size. So
Right.
I don't know if you
So
want
it's
to make,
approximation. It's
Okay, yeah,
approximation, but
would you want to make those adjustments that we know are being made, like the true up adjustment? Yeah, I'm going to confirm with Mike Ripperger that really will be $1.8 million taken out. It seems obvious to me that it would.
okay, so we take that one out since that wouldn't be appropriate for 2022.
And
But-
then, like I said, we still have uncertainty with regard to how the ARS payments will be different next year, if at all.
Which payments? What did you say?
The access reduction
Oh,
support.
ARS. Yeah.
It's uncertain how those will be different. So maybe I'll just explain. We kept that number the same because it's going to be, it may probably be a different number, but we don't know. We're still in the process of deciding that. And I'll also mention, I think we probably should make some minimum, at least, adjustment for the fact that the Sacred Wind payment will be in place in 2022. That was estimated by staff in the FIR at I think 970,000, although they said it could be up to 2.5 times that. So we could plug in a number there and explain, these assumptions that are being made for that.
What's the magnitude of that again? I forgot that number.
For the petition, it would be
for Sacred Wind.
Yeah, the Sacred Wind petition, the FIR that was done by staff during the legislative session this year, I think they came up with 972,000 annually, I believe. And then they said, but given the sort of general nature of the broad general terms that are used in the legislation, it could be up to 2.5 times that amount. So there's a broad range there, but we can make an assumption especially since you're this table is really about just giving an idea of what the effect on the surcharge would be at various hypothetical increments, and that would just explain why it's going up to a certain increment.
Yeah. Well. Okay. So so you would want to put something in the table that would capture the impact of the Sacred Wind participation. You could even show both points, the low estimate and the high estimate, I guess.
Well, I guess,
but I don't know if you need to. We're not really interested in that so much. I would just put in the worst case scenario, the 2.5 times.
Yeah, that makes sense. Yeah, because I think the table will just add a bunch of columns from 35 million to 57 million, and there won't the reason why why it goes up to a certain number to that 57 million is what will be explained in a paragraph. That will just be
right. And I had forgotten the size of that component, and I had forgotten about adding that in. So, I was just looking for a rough estimate, but it may be that we need to go up to 58 million or something, or 9, to make sure that there's enough headroom to, be able to pay out $37 million. 37 million.
And whatever it is, I can, if the commission adopts this version of the order, then I will, I'll figure it out right away what the approximate, what that end amount will be, and I'll provide the description of why that's the end amount in the table, how it's an estimate really for 2022. If you were to fund all broadband program funding, program applications, plus take into account some changes that will happen, but we may not know the amounts, and not including any changes that might occur to the ARS payments because those are uncertain at this point.
Well, okay. Well, I was just asking, can we get the sensitivity analysis and look at this again, or is this the last day we can have to vote on this?
Yes,
Because-
actually, this is due on Friday. It would be an Open Meetings Act violation for the commission to make any collective changes after,
Okay.
outside of an open meeting. We're not having the open meetings between now and Friday, of course. The commission could, if the commission adopts your recommendations, Commissioner Hall, the commission could simply say, continue to work with Commissioner Hall on her changes, and you and I could continue to work on that. It would be an open meetings violation. It would just be because there wouldn't be any other commissioners involved. It almost would be like a sort of single signature order sort of issue, a delegated authority, because these are the revisions that you are recommending.
Okay, well, what's left undecided though is whether or not we would agree that the surcharge would be of a magnitude that would be acceptable to the commission, or at least a majority of the commission. And we don't know that until we do the sensitivity analysis. So I don't know how we want to proceed at this point. But I think it's worth looking at because, we only have 5 years of this sensitivity analysis. So I don't know if we could conclude that we're looking at, a straight line increase or what. I mean, I noticed the increase is, it's either 3 or 4 cents in between years. And if that's the rate at which the increase continues, we could sit here and, estimate worst case scenario, it would be 4 cents a year.
Well, if my understanding is correct, I'm concerned that this, I may be oversimplifying it, but I believe that if you take the total funding requirement, I can confirm that right now. You simply multiply or divide the funding requirement by the number of communication connections that are projected for 2022, because I explained, is that 2021?
Chair, if I may.
Commissioner Maestas.
Just on point here, I appreciate kind of exploring these scenarios using the sensitivity analysis, but let's keep in mind that based on the 2021 size of the Universal Service Fund, the broadband program only occupies 42%. So if let's just say we decide to go increase the Universal Service Fund to 35 million, that only translates to a $2.1 million increase in the broadband program. So perhaps we ought to at least include a corresponding change to the broadband program, because that sensitivity table is just looking at the Universal Service Fund and incremental increases to the surcharge. So it would probably be more accurate if we also include a corresponding change to the broadband program, assuming that access reduction support remains the same. So we'd apply a 42% multiplication factor to the total Universal Service Fund. So does that make sense? It's not adding the 22 million to this Universal Service Fund is not going to fund all the broadband program requests. It's only going to really fund 42%.
Right.
Actually, commissioners, can I explain something?
Yeah, it seems to
that's
me,
not actually the case.
Yeah, that's what thank you.
Yes,
Go ahead, Russell.
It's not the case that every additional dollar is divided within the fund is divided in a percentage-wise basis. Those fund obligations that are described above are dollar denominated obligations. The percentage was simply provided for, just for informational purposes. Is like access reduction support payments for 2021 are $16.4 million. So once all these fund obligations, other than the broadband program funding,
are added together, that's the total that you're subtracting from whatever the cap is. And so every additional $1 million in the cap can go entirely to the broadband program applications.
So Russell, just to clarify, the access reduction support is a fixed number, $16.4 million, correct?
Yes, I mean, the calculation may change for next year if we're looking at 2022 instead. That's sort of one of the reasons I didn't really want to focus on what will happen next year and just focus on changes. I just make hypothetical changes to this year's numbers. I think that's a little. One thing, and Commissioner Hall, the comments you made about about discussing in the funding obligation section what will change in 2022 make a lot of sense. But I think what we're seeing now is that the reason I just worked with 2021 and didn't do any sort of projections. I did. There's let me focus on this. Was that it just kept things a little clearer, and I think since we're just doing a hypothetical sensitivity analysis here, that we should maybe just stick with the 2021 for clarity. But it creates these other issues because Commissioner Fishman is asking me, is 16.4 the amount? It's the amount for this year, but then we have uncertainty as to what it is for next year. So what you have in this table, or at least the description of the numbers in the table, is we came up with this hypothetical $58 million based on a hypothetical change in the cap, plus these future adjustments to the current numbers that you see in the table. It will be very complicated because we'll be mixing the future adjustments. We'll have to explain that and what's hypothetical. So it does make it a little complicated, but that's fine. It's absolutely fine. It does make sense to talk about those as well. This is illustrating to me why I chose to keep a 2021 numbers. So, but it is again. This is a decision for the commission, and those are very reasonable things to point out that what's going to happen in 2022. I try to avoid it in these sections just because I felt there's another layer of complexity.
And Russell, excuse me, Commissioner Hall, for just a second. Is right now the $30 million that's in statute, right? It's a statutory limitation.
Correct.
Yes.
Okay, so what we're illustrating here is a potential ask to get legislative action to increase the fund.
Correct.
Okay, just to be sure we're all on the same page there.
And
Right.
Commissioner Fishman, I don't know if the implied point you're making is that if that happens in the next legislative session, it wouldn't be effective for the entire year next year. Anyway, it might start in the middle of the year. It might start at the beginning of the following calendar year because the legislature would make it retroactively effective. And certainly we can't do any of our planning based on the idea that there'd be an increase in the cap in the next legislative session because of the timing of the session. So that may be another reason to avoid 2022 in this discussion at all. The uncertainty of the number and the fact that a change in the cap really couldn't be applied to 2022 numbers, period. Now, obviously it can't be applied to 2021 numbers either but I think it would just be clear. We would just be saying, well, if you just use the numbers we have for this year, which are the numbers we use above, and then and use those numbers and don't even talk about what might change in 2022, then you can you can say these hypothetical cap numbers, are just taking that into account. And so it might not go up to 57 million. It would, but then again, that plus you're including the amounts of the applications for 2021 in this. So I don't think we want to include it might be confusing to also include these are the applications we're going to decide in 2021. Of course, those are used to, that is the number we plug in for the fund side for the amount to be funded in 2022. So it does make some sense. I'm sorry, the more I think about it, it's extremely complicated to decide.
So as an action question, Commissioner Hall, is your thought that we would for this budget session, find someone to carry a bill to say, let's increase the size of this fund, the maximum size of this fund for fiscal year 2023 in order to keep the numbers simple. Is that where you'd be headed with this?
Well, if that's the soonest we could accomplish an increase in the fund, yes. I'd like to go back to what I was saying when I was interrupted by first Russell and then Joe, and I was right at the end of a point I wanted to get to with this, because I think it still has bearing on our conversation, and will help the conversation, I think. And looking at the sensitivity analysis, it covers change between 30 million and 35 million. If you carry it out another, say, 25 million to, what is it, or 20 million to $55 million, which would be fall a little short. It'd be better to go 25 million. It may be looking at the pattern of increase here year to year, it's either 3 or 4 cents. I don't know if that would hold, but even if it's in that range, if you estimate for the subsequent 20 years to get up to 55 million over 35 million, that would be an increase in 20 times 4 cents, which is 80 cents. So that increases the surcharge to something under $2. So you could add, hypothetically, something around $37 million ballpark with an increase in the surcharge of about 80 cents. I was just trying to imagine what can we do and how far should we go to increasing that surcharge to get, and then that would give us an idea of how much to raise the cap.
I see what you mean. I think you're right. What Commissioner Maestas had placed in here, was clearly like the step from 30 million to 35 million was just like it's clear why it stops at 35 million. It's just like, let's just look at 5 years just to give us an idea, I think was the idea there. And if the commission adopts a recommendation to the legislature to increase the cap to fully fund all of the obligations of the fund in 2022, even though that couldn't be done given the timing of the legislative session, it could be, partially done probably. Then we'll simply, maybe the commission wants to decide on how much they want to increase the cap, because then the reason for going up to that number will be because it's the recommendation of the commission. And then instead of explaining with regard to the table why we go up to a certain number, if the commission adopts that recommendation, we'll be explaining in the recommendation itself why the commission is recommending this cap, which is because based on what the applications are this year, which will be rolled into the funding obligations for next year. That's how we generally calculate it. To fully fund all that and the highest possible sacred wind payment and the other amounts as they are currently, then that is what the cap should be. So then this sensitivity analysis, it would be clear why it goes up to the new recommended cap amount. So I see what you're getting at. So maybe you want to discuss what the recommendation will be then before getting to.
Can I respond to Russell Steve first?
Well, just let me make this one comment real quick and respond. It seems to me a simple way to do this is just take the table that we've got, and instead of doing it in $1 million increments, do $5 million increments.
Sure, whatever.
And that'll illustrate the numbers pretty clearly. And if we want to make a legislative proposal, we're covered.
Well, Steve, Mr. Chair, the reason I was comfortable with 1 million increments was because I was watching the increase in the surcharge. And I don't know whether the increase in the surcharge would increase, would it go up to 5 cents or 6 cents? And I guess you're saying maybe it's not all that important. But I think we should keep our eye on it, only because it was certainly an item of controversy in the past, mostly among the commissioners. So, but if it's not increasing more than 4 cents a year, and maybe we can rely on that. Huh?
Yeah, it's 3.5 cents, approximately 3.5 cents per $1 million. And that's a fixed number for however much we increase it. So there's no mystery there. Each extra million we want is going to be a 3 to 4 cent increase in the surcharge.
Right. And so
yeah,
I think that strengthens our argument for raising the cap, because we have a rational basis for saying that we'll be able to keep the surcharge under $2, for example. And then, since that's not that, I know that's a certain percentage over 112, but I think there was information showing that, let me see, on page 2, for calendar year 2018, the surcharge was $1.24. So, it's been higher in the past. So anyhow, if we're in a reasonable ballpark with the surcharge, we can feel better about ourselves, at least, that, our recommendation to increase the surcharge, increase the cap by an additional, say, $40 million, would be something that wouldn't be too onerous on all the cell phone owners in the state that have to pay that surcharge.
Mm-hmm.
And Commissioner Hall, can I make I'm sorry, but can I make a comment here? Because it might help.
Yeah.
I assume that any recommendation that the commission, this is an assumption, would adopt with regard to raising the cap would be for a round number. And that could actually, if it is 60 million, say, then this could be very much simplified. The table wouldn't have to do all the increments. We could, that we could, in the description of why the cap is reached that way, we could simply say something much simpler than going into how much the Sacred Wind petition amount might be. We wouldn't have to get into the specifics. We could simply say, or we could, if you want to, that this $60 million proposed cap doubles the cap and would cover all of the obligations of the fund in 2022, even at the highest amounts for the uncertain amounts within that, it would cover those highest amounts. This is a cap that would cover all of the obligations for 2022, even though it's not going to be applied that way. You'll say that's how we've come up with it. We have increased burdens on the fund, and whatever they will be for next year, for 2022, 60 million will cover it. So that makes sense for a cap, something like that. But I'm just
I'm not quite following you. I know that we got a request. Let's see.
I guess, Commissioner,
the funding request that
we could have a sort of abbreviated discussion of like what the possible amounts for the Sacred Wind petition might be, what the true ups are going away. We could avoid that kind of detail and just say $60 million would cover all of the 2022 obligations, even though some of those amounts are uncertain at this time. We're certain that 60 million would cover all of those. So we've chosen that number because it clearly covers the highest projected obligations and broadband program funding that have so far been existed in the fund.
So Russell, are you saying the $60 million ask would cover all the applications this year for $37 million? We're asking for next year, right?
Well, Commissioner Hall, what I'm saying is you were talking, we've been talking about this table in the context of the cap. And what I'm saying is maybe one way to discuss this that might be easier is to say, well, first of all, does the commission want to increase the cap? And if the commission wants to increase the cap in accordance with Commissioner Hall, with the notion that we should cover everything we've been asked for, you're going to want a round number. We're 50.
I agree.
You don't need to say 57 or 58. You're going to want to say 60 million. And then what I'm saying is it will allow us to do just not have to get into the nuts and bolts of exactly why we get to 57 or 58 blah 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 million, because we can simply say 60 million would cover will certainly cover the all of the obligations of 2022, including the granting every broadband program application. And we won't have to get into specifics of, because if you want to instead provide that specific number of what that might be and some estimate of what it might be, and with the uncertainty, we'd have to get into all kinds of explanation of why the sacred wind number might be this to this. And
I understand what you're saying. That's fine. I do understand what you're saying. It's better to keep it simple. But I would not say 60, I would say 70, because I would say we should increase it by 40, because the applications that we got in this year are $37 million, not 30, 37. So let's just, if you don't ask, you don't get. And if they want to cut it down, they will. So we might as well ask for 40 million rather than 30 million, because we've got $37 million worth of requests looking at us this year that we can't cover. And a number of them may come back, as you described or in the report, and a number of them may not. But if we get more money from the legislature, they will maybe that will influence them coming back.
Commissioner
That's
Hall,
what I would argue.
another question. Are you proposing that we include that request in this report? Or do you
Yes.
see that? Yes. Okay.
Yes, we have a big blank space there. The commission recommends. Well, we just got $37 million worth of applications that could be put to very good use if we had the money to pay this year. We don't have the money. And so we're asking for money for next year. Well, what's going to happen? Those people still need broadband, and there's still this strong mandate in the state to respond to it. Why don't we just respond and say, okay, you want us to do something? Give us $40 million more. We can see that at least this year we've had that many requests. They may return. We want to be ready.
Okay, Commissioner Hall, and I'm understanding that. I just want to make sure that I'm completely understanding it, because one thing that does, if you're adding $40 million to the $30 million based on the $37 million in broadband program funding requested, what you're not taking into account, and maybe you don't intend to, I just want to clarify this, is that some portion, not the majority, but some portion, probably somewhere between 10 and 15 million, probably around 10, 12, 13 million, will actually be recovered under the $30 million cap as it is. It's not as they weren't all going to be denied. So 30 million, adding 30 million to the cap actually would cover all of the obligations for the broadband program funding as well, because all of the 37 million is coming up on top of the 30 million. 12 million of that approximately will be covered by the.
We can cover it. That's right. Okay, fine.
So I think 60 might be the number you might want to use in that case.
I'll go along with that.
And I just want to note to the commission, I did, I had said that we're not having any more open meetings, but Michael sent me a text. He said we could continue this open meeting to say Friday or tomorrow to continue to discuss this matter as depending on the availability of the commissioners.
Well, Mr. Chair, I think I would just recommend that we increase it to 60 million and cite the fact that we've gotten this, we have been getting increasing requests, reaching up to $37 million this year. And I'll leave that open to discussion. If somebody wants to reduce that amount further, maybe, I mean, maybe if we're just getting a request for 37 million a year, maybe they'll say, well, you only need 40 million a year. I don't know. But if you start high, then they can always cut. But if we start too high, they might just say, hell no, I don't know. But I definitely think we need to raise the cap. That's what I think. And I think from what we've seen from the sensitivity analysis, it has not a big impact on the surcharge. So those are the two things that I'm concerned about.
Did we manage to get a hold? Wow, there's a big echo.
I don't hear it.
Okay. Did we manage to get a hold of Mike on this, Ripperger?
I saw it. He's on. He's on.
I'd like to hear from a larger perspective, what other efforts are going on in telecom? And if we do this, how does it impact them?
Yeah.
Mr. Chairman, Commissioners, as far as if you're talking about larger efforts in telecom and money that's coming in for broadband, or are you just talking about the fund itself, the State Universal Service Fund?
Fund itself.
I'm talking the bigger picture. What other things are going on in terms of telecom funding? What's the money, broadband funding? What's the money likely to go to? How does this impact any broader state strategies that might be developing as we're getting ready to consolidate management of all the different broadband efforts? How does our increasing this fund impact that whole picture?
Okay, all right. There is a lot of money that's coming in to the states. There's a bunch of NTIA money. There's a bunch of money that was allocated to the states to I guess municipalities and other folks who have to spend that or say how that's going to be spent pretty soon. I mean, we're talking somewhere in the range of, it really depends. There's also tribal funds, a huge amount of tribal funds that come in, but it's one thing to get a whole pile of funding in, and it's another thing to strategically allocate that to all of the needs in the state. So I don't know if all that money that's coming in from all the different sources is actually going to be applied for and then spent in the state. That's one of the reasons why there's a central broadband effort going on in the state. There may always be a place for this type of funding for carriers because it's pretty predictable at this point. I don't know realistically how much of all of the other monies people are going to be able to get in the state. And the only way to find out is, if people, let's say they don't get the funding through this program, they go and try for funding in another program. And then at the end of the day, you have to have a centralized locale, which would be our state broadband office, recording where all that money is spent. And then, they have to try again. So I think just because a lot of money is coming in or is possibly available through a lot of different sources does not mean that it will neutralize the usefulness of this program because it's proven to be accessible. Oh, and just to get back to the two questions that you had about the 1.8 million, my understanding is that's expiring at the end of the year. And the Sacred Wind demand, I know in the FIR, I said possibly 2.5 times greater than that. But more realistically, you're probably looking in the, we don't know yet, but in the $1 to $2 million range. We just don't know.
It's almost a wash.
Yeah, they're very helpful. Thank you, Mike.
Well, Mr. Chair, I guess what Mike says kind of reminds me of what the impression was that I got was that, while this centralized effort is getting on its feet, they're probably not in the position that we're in to actually start doling out money to applicants who are ready to go, and we can see that they're going to unserved areas first, underserved areas next, and our system is in place. And I just think we should not drop a ball here when we could be serving the public while the state is getting its act together, or otherwise to centralize the whole function.
Hey, Commissioner, just to add something to what, sorry, go ahead.
No, I'm done. That's fine.
Yeah, add something to what you're saying. The language that I already put in about the dramatic increase in program applications since the COVID-19 pandemic began, illustrates that these are projects that are needed, right away.
Yeah.
To serve areas that might not have been willing to pay for broadband program funding if they're particularly poor areas, for broadband program for broadband access, but now critically have to have it now. That goes right with this argument that you're saying, that no matter what's coming in the future from the Connect New Mexico Council and the broadband Office of Broadband Access and Expansion, we're here now ready to grant a whole bunch of applications, as many as we can, because this needs to be done now for COVID, for access to especially education. I'd already include some language like that, so it really supports what you're saying, which is that this is for now.
And plus, once centralization gets in place, we can recommend our fund get reduced, for that matter. I mean, this is not a permanent change.
Well, we're never obligated to go all the way up to the cap. The cap's just a cap. We could decide to do 40 million one year, and just depending on what comes in. So there's a lot of flexibility there, it seems to me.
Yeah.
Other commissioners, in listening to what Commissioner Hall's been talking about, it seems to me the only controversial thing for us, or at least for me, is how much we would ask the legislature for in terms of the cap size on the fund. So I don't believe all commissioners would necessarily agree we would do that. So if there's anybody who disagrees with doing that, please speak up and let us know your reasoning.
Mr. Chair.
I kind of figured I'd hear from you, sir.
So I don't think we should be increasing the fund size, and here's why. We have increased taxes and cost of living's going up tremendously over the last year. And this just adds to that burden. And remember, it's always about the lowest among us and how that impacts their weekly budget, and every little bit makes a difference. The legislature could have fixed this by simply going back to I believe it was 2004 bill that named specific companies as to how they will handle their billing. And at that time, Sacred Wind did not exist. So Sacred Wind has to do this separate type of funding from this program, which wasn't originally meant to support these companies. Had the legislature simply went back, took out specific names and just said companies that fall in this category, Sacred Wind would have been included, but they're not included on the list. And I think we need to recommend that they go back and just change their, it's one of those things that, well, we'll fix it in the future. They still haven't fixed it. And so they just need to go back and fix the law as currently stated so that Sacred Wind is included. And then that frees up that money that is being given to these other companies.
What's that? I didn't understand that last part. What frees up what money? The money that would
the
be
money that Sacred Wind is going to be proposed to get, and that they're being given money because there's a law that specifically named carriers. But Sacred Wind was created after that law was written.
Right.
And rather than
Didn't
going
we-
back and just fix the law, they've chose to allocate a money out of this fund that should be for broadband use. And it would have been simpler just to change the language in
But-
previous legislation.
I don't see how
Correct
that
me if I'm
addresses
wrong.
what we're talking about now, though.
Yeah, correct me if I'm wrong. Russell, I thought the legislature passed a bill that allowed Sacred Winds to be part of the RUSF.
Yes,
Or
Mr. Chairman,
Michael-
Commissioners. Okay, so go ahead. I'm sorry.
Michael or Russell, either one.
I think I can explain this. When the access reduction support payments that are currently paid to the rural ILECs, with the exception of Sacred Wind, are a result of I think it was actually when the Rural Telecom Act of New Mexico was passed. It was not amended, but when it was passed in, I think, 2005. Commissioner Byrd said that the rural ILECs receiving those payments were named. Actually, they're specified, but not by name. They're specified as all of those rural incumbents that exist as of this date. And as Commissioner Byrd said, Sacred Wind didn't exist as of that date. They existed a year later, and they were, a rural ILEC in every sense, except that they weren't by that deadline. So that's absolutely correct statement of how that happened. And the Sacred Wind legislation that was passed this year, that is described in this report, would give says give a comparable amount to Sacred Wind. It doesn't mention them by name, but they're the only one that falls within the category. That's similar to the ARS payments, the access reduction support payments. So it does correct that. The one thing I would say is that it's not all of those amounts. The old access reduction support payments and the new Sacred Wind petition will all come from this fund. So like amending the what was done in 2005 to include Sacred Wind wouldn't. It's all coming from the fund either way. So it wouldn't alleviate any burden on the fund. It would probably be basically the same result, because it would be a similar amount, because that's what the Sacred Wind petition is trying to do now. It's trying to say, hey, you didn't include Sacred Wind because they were too late, but give us an amount that's about the amount that they should get. They would have got, basically is what it's saying, or comparable to what those other rural ILECs are getting. So it's going to be about the same overall burden on the fund, somewhat increased burden, including Sacred Wind. I don't think there was ever a proposal to make those payments from some other source of funding.
So for all purposes, just to say it as succinctly as possible, for all budgeting purposes, Sacred Winds is part of the RUSF.
Yes, just like any other access. Basically, the bill was to make them an access reduction support recipient in everything but name, because it says we'll give them a comparable amount. Just because they were left out because they were 1 year late, just give them a comparable amount. So they'll just increase essentially the access reduction support payments by an additional carrier in the amount of $1 to $2 million.
Okay, so from there, let's go back to Commissioner Byrd and continue. I just wanted to be sure we all understand the facts of this. Commissioner Byrd, did you want to continue?
Those are my two reasons. They set up a different fund than the broadband fund for this. Could have been done at the legislature. And I don't think we need to be increasing costs right now when costs are skyrocketing.
Okay.
Just in general.
Mr. Chair.
Yeah, Commissioner Maestas.
Yeah, I agree with what Commissioner Hall said, that, until, we're a state in transition with respect to broadband, right? In terms of funding and organization and establishing this clearinghouse through the broadband office and NMDuit. And so I think we're going to be a player only temporarily until the statewide broadband plan is established, because there is a distinct requirement that our projects have to be consistent with the statewide broadband plan. But that could take as as many as 3 years to develop. And so I think Commissioner Hall is spot on. I think we have an immediate need. Our process is tried and true. And so I advocate also for increasing the surcharge and the overall fund. However, I can't ignore, staff's recommendation to leave the fund unchanged because of the impact to ratepayers. And so I'm sensitive to that. I'm also concerned about kind of maybe the reactive nature of going for a much larger increase because we had a high level of broadband applications in 2023. I mean, that information could be stale. Maybe it's right on. Maybe there'll be even more broadband applications in succeeding years. But I want to make sure that I think that our request is measured and sound. For example, we talk about rate shock all the time. And while there is no definition of rate shock, I consider like a 20% increase to be pushing, or 20% plus to be pushing rate shock. And I know that looking at the surcharge individually, and we talk about the relative increases to increase the size of the Universal Service Fund, may not seem like a lot, but I think we need to look at the percentage change as well. So I support an increase. I really am sensitive to minimizing that increase and prevent it from getting into the rate shock area, i.e., plus 20%. But I do think we need to start thinking about the future of this fund and recommend to the legislature that we have automatic increases, whether we index it tied to the CPI, instead of just working with the whole number, knowing that costs are going to go up, demand we know is going up. And I think we're employing a real clunky response in this fund. And I think Commissioner Hall is right. I mean, we need to be responsive to meet the needs, but I think we need to temper that with a huge increase. Just as a matter of general practice, I don't like significant policy changes. And while I would love to fund all these applications, I think we need to look at all the other facts, like the relative increase, the percent increase in the surcharge, the justification for the increase, but then also asking if the legislature to perhaps employ some automatic increases or give us additional latitude going forward in increasing the cap to meet the broadband needs. But look, at the end of the day, in 3 years, I think we're going to be a bit player. I think that this whole process is going to be screened, and we may be even vetoed in some of our recommendations, especially if we depart from our own established criteria. And so, do we want to make this wild swing and almost double the fund to accommodate a short-term need? And I'm just wondering what the perception would be of the legislature. And I think we probably should be a little more measured, but yet think about the future and come up with a mechanism like indexing or something else, an automatic increases to the fund in successive years. So anyway, I support an increase, but perhaps not so much.
Okay. Commissioner Vicente Aguilar, what's your perspective on this? Whoop, did we lose her?
Mr. Chairman?
Oh, there you are.
Okay.
Go ahead.
I was muted. I'm sorry. Thank you. First of all, thank you for the time. I believe what Michael Rippiger has said is true, which is telecommunication companies are receiving a lot of funds to the state of New Mexico. And what are they doing with the funds? Certainly they make reports to the utility division here in our agency, but it's very quiet from our staff members. So it's an automatic approval for any request. Through the years, I'm talking about more than 10 years, there's no scrutiny. There is no way of knowing what the term need means in certain parts of New Mexico. For example, one company received $159 million in 2014 to connect New Mexico, whether it's telecommunications, broadband, and then we don't know what happened to that $149 million that one company has spent. Another company received $79 million in 2011. And we don't know how that money was spent. And if you read about FCC's ranking about broadband services in the states, New Mexico is ranked 48th among the 50 states. So you ask, all this money that's coming to New Mexico, what are the telecommunications company doing with the money? I would like to ask in this report that's going to the legislature that they ought to do an audit on all the programs that were funded. If they truly want to understand to expand broadband through many communities in New Mexico, they need to have that history and the background. If the legislature is serious, and also disclose a copy of their status reports on projects, if the legislature is serious to centralize broadband services. And also, they should get a detailed listing of all the federal grants the telecommunications companies has received. I would like to ask the legislature to also design and audit procedures that are appropriate for the current circumstances. I would like to ask the legislature to evaluate the appropriateness of rules that are used. I would like to also ask the legislature to schedule expenditures of the federal awards. If they want to centralize and expand broadband, that is the proper way. And all this could be achieved if it's in a reasonable assurance in uniform fashion for all the telecommunication companies. My constituents, they tell me day to day, they're afraid to voice their opinion because they know who the CEOs are amongst telecommunication companies. They're going to be targeted. They're afraid to complain when their child cannot receive internet service in an isolated home. So they asked me to speak for them. Another constituent, when she complained, the company came in and said, we're going to give you the top graded internet service to your home and only your home. And all the other homes that are situated 10, 15, 30 miles around her home, they don't get internet service. Only you, and you keep quiet. That's what my constituents are telling me. So I have many concerns, Mr. Chairman. Yes, we have staff members in our agency. This is the state government. We only have a couple staff members that are doing the best that they can to provide a report to the commission and also to the state legislature. They're doing their best. But there's a bigger world out there where there's the shortcomings and the audit procedures are necessary. So that is my evaluation about this item on the agenda. Many times I'm told to be quiet. Many times I'm told don't say anything because this is a pending issue. But this is the real world. My people are hurting. Grade A students, I talk to school board members. Prior to pandemic, students that are straight A students are now at the grade level of C's and D's because they don't have internet service. So, Mr. Chairman, thank you. I appreciate your time, and I'll let my, I'll just let my colleagues take it from there. If it's, I just want everyone to know this is how I feel about the situation. It's very, very bad. We're ranked 48th in the state. That's my conclusion. Thank you, Mr. Chairman.
Okay, thank you, Commissioner Vicente Aguilar. I'd like to make a suggestion here if the commissioners are amenable.
Mr. Chairman, could I just respond to what?
Let's not do that yet. We can.
Well, I just want to incorporate some of her comments in a proposal I'd like to make.
Okay, go ahead.
Well, I simply want to say I agree with the last point that Commissioner Vicente Aguilar made, which is this is a hard time right now for many people. Kids are still needing internet for school, and that's why I think the fact that we stand ready to dole out funds for applications that are in front of us, is a good reason why we should, at least in the short term, and do something to increase the funds so that we can respond to what comes in the door. And having heard the conversation especially from all three other commenters, Commissioner Byrd, Commissioner Maestas, and Mike Rippiger, I want to alter what I'm proposing to maybe seek an increase in the fund of, say, $10 million for the next 3 years or so, or next 2 years, so we can be more responsive in the short term, because the short term is where we're having a crisis right now, as Commissioner Vicente Aguilar eloquently described. And I agree with Commissioner Maestas's remarks about the effect of which in my mind were that we shouldn't ask for too much. We should ask for something that's measured, and I agree with that. And I also agree with Commissioner Byrd's concern about impact on, everybody's expenses are going up. However, I think what modifies my thinking here on that is that yes, the surcharge will go up to some extent, but the incremental increase, while it will be add to hardships for everybody, they will work a real strong benefit to many people who absolutely lack what most of us think is a basic utility. So I think in the short term, and certainly for this time in our state, when we're trying to grow broadband as fast and as well as we can, we should impose that small incremental cost on everybody else to help this portion of our state reach a minimum level of service from broadband. So,
Okay.
so that's what I would propose. Maybe an increase of $10 million would get us through.
A comment is that I think Commissioner Vicente Aguilar raises, a good point. Her question essentially is, where has all the money gone?
Yeah.
And I think it's a really valid point. And we do have limited follow-up in terms of when we approve these projects and what actually happened as a result of getting it. We've got it on paper, but it's not something we've field verified, if you will. And I think Commissioner Vicente Aguilar, we don't have control in our program over, all the funds across the board. But, maybe there's a couple things we can do better in terms of verifying what's actually happened out there in the field, and at least address, I think, the very valid concerns of Commissioner Vicente Aguilar in terms of verifying what actually happened and that we got what our money paid for. And what I was going to suggest is there's enough happening here, and I'm hungry enough. And I need to go to the bathroom, damn it. I was going to say, let's take a lunch break, come back and see if we can complete this discussion, and we'll have an hour to let it kind of sink through our brains and maybe come up with something specific for what we want to put into this report that we have a reasonable consensus on for following up with the legislature. And, I know Commissioner Byrd, you may not be on board for this one. Commissioner Vicente Aguilar, I'm not quite sure where you are, but I think we've heard some good comments that we can incorporate into this memo when we come back. So with that, if folks are amenable, I'd like to ask for a 1 hour lunch break because we've been going for 3 hours, and that's a long time. And then
Mr.
come
Chair.
back and finish up on this item and our discussion items.
Mr. Chair, would it be possible to maybe cut that to 30 minutes? Because I've got a 2 o'clock I'd like to get to. If we could finish in an hour.
Let's get back here at 1 o'clock. It's 12:24. And we can just work with that.
Okay, thank you.
Okay, so let's adjourn till 1 o'clock and complete this valuable discussion. Good points are being raised.
Thanks.
Thank you.
Hello. Who is back?
Howdy. Some of us.
Commissioner Byrd, always on time.
I'm here.
Who's
I'm
on?
here.
I'm here.
Okay. I got a lot of I'm here's, so I'm going to assume those were commissioners. Commissioner Hall, you back?
Yes, sir.
Okay. Commissioner Maestas?
Yes, sir.
Okay. So we're where we left off, and thank you all for considering my need for a break there. Commissioner Hall, you were making a proposal, and I don't know if there were any specifics that you were going to make beyond saying let's recommend a $10 million increase in the fund.
For 3 years. Or it could be 2 years. I mean, that's up for discussion. All of this is, but just simply because, I agree with Commissioner Maestas's, reference to the fact that, consolidation will take 3 years, 2 or 3 years possibly. And in the meantime, he agrees we should be trying to operate. And also because, Commissioner Byrd, I agree with what Commissioner Byrd's viewpoint is, having to do with keeping the payment, the surcharge, as low as possible. I just think these are extraordinary circumstances. And for a few years, while it works a minor hardship on a lot of people, it saves a lot of people, not quite as many people, from being, basically, isolated from most of society if they have to stay home with no internet. So 3 years max, could be shorter, I guess, but at least $10 million doesn't look like we're being too grasping, and that would have accommodated the 37 million. Well, no, it wouldn't have. But it would have gotten us closer. I'd like to ask the commissioners if they have any thoughts about that, because we got a request for 37 million in applications for this year, which we couldn't cover. Access reduction payments and other costs take quite a bit out of the fund. So if we were to anticipate, say, another year where we got maybe, I don't know, 25 or $30 million in requests, what would we want to ask for an increase?
Well, if we did $10 million, that would accommodate somewhere between $20 and $25 million of projects each year, if we went to a $40 million cap.
Yeah, and that's short $10 million from short $12 million from what we got this year. I don't know if this year is the worst.
Which isn't necessarily bad, because not all of those proposals are necessarily good ones. So
I guess so.
that's
I don't
something
know.
to evaluate too.
Yeah.
Other thoughts from commissioners?
I was wondering if Commissioner Maestas had any thoughts in particular, because he thinks about money.
I support that. I would support increasing the cap to 40 million.
Okay.
And that corresponding increase, I think, would coincide to, I think, the historical high or close to it in the surcharge.
Yeah.
So I think that's a good increase.
Okay.
I'm good with that as well. 10 million, $40 million cap, beginning 2022 fiscal year. And I like it because it's nice and simple. The fund might be subsumed in 3 years, into other programs as they consolidate. And, we may as well keep it simple, and we don't need cost of living kinds of increases each year. But I also would like to incorporate a thought from Commissioner Vicente Aguilar that maybe we can set aside $50,000 out of the fund to field audit to be sure we're getting what we're paying for. And because I think that she has got her finger on a very important point. And let's face it, phantom assets are not a new thing. We see it all too often, and I think it'd be wise to add that bit of I would almost call it compliance assurance to the program. So I'd love to hear other commissioners' thoughts on that. And Mike Ripperger, if you have a thought on that, love to hear your perspective as well.
Mr. Chairman, commissioners, there's two aspects to audits. One is an audit of the projects which are already built from the broadband program, and the other one has to do with State Universal Service Fund use reports for access reduction support funding. So those are two different aspects of the program that could be subject to some form of auditing. So that it's not just broadband projects, it could be money that's spent for universal service purposes for access reduction support.
Do you believe that would be useful?
Commissioners, I mean, right now, I think that, the carriers are reporting in good faith in case 18196 UT, but I don't know how actually useful those reports are per se. In getting to what we're getting at, I think it would need some more, a little more scratching around. And I know that the carriers feel that they're certainly spending the money in good faith, but I think it could use some, at a minimum, improvement. And I think you could go a little deeper on it.
Is it the kind of thing that you can find a contractor to do and that we could do it on that kind of basis? Or how would you go about it?
Well, I mean, I think you would need to bring someone in to investigate what is the best way to go about doing that. And there are professional outfits that do that sort of stuff. I don't know. And there may also be an issue, a legal issue with authority for audits. That's been an old issue, but I think that there are outfits that specialize in telecommunications and telecommunications reporting and looking at all the different things carriers do just to get more detail on that.
Right.
Because carriers get a lot of different funding from a lot of different areas, and they spend it in a lot of different areas. Sometimes it may not be that easy to tease everything out.
Yeah. And what would be a number out of the fund? It seems to me if we set up a little audit fund, it would come out of the RUSF fund. What do you think an appropriate number would be? I know you're guessing at this point.
Yes. You could throw out $50,000 and say, okay, maybe that's an amount. There's also an issue of, do you have rolling audits or audits all at one time? Is it a regular thing where you pick a carrier on this year and you pick a carrier on that year? And that would spread out the sort of auditing if you were to put in a more of a permanent audit mechanism. But again, what do you really need? I think that you would need to consult with some professionals, I think, beyond what we can do to let them tell us what they think you would need in order to make sure all that was being done the way it should.
So if we were to put a starting number into this communication with the legislature, what would you pick?
Mr. Chairman, commissioners, my thought is 50,000 is a good number to start, but again, you might be looking at two different audit procedures. I know that we do get reporting for the broadband projects, but and I know that our engineer was planning on doing some site visits before COVID hit, and then that sort of stopped that.
Right.
So, it may be less, you may need some, some assistance with that wouldn't hurt. But I think that possibly the audit for the access reduction support would be a little more complicated, I think, and take a little more investigating as to what the best way to do that is. 50,000, but again, you might be looking at two different pieces.
Okay.
Says 50 to 75. 100,000 seems excessive.
Yeah.
But I don't know until we would get into it.
Well, and this would be a number that would just be kind of a placeholder that, if it got to legislation, we'd have plenty of opportunities to fine tune that number. Go ahead.
Okay. No, that's about it. I mean, I think in staff's report, we had mentioned a little something about that. So yes, it never hurts when you have programs and you're doling out money to have some sort of follow-up audit procedures for those.
Okay. Commissioner Vicente Aguilar, what are your thoughts on this?
Yes, thank you, Mr. Chairman. My thought is that the whole system is broken. These telecommunication companies do not have dollar for dollar oversight whatsoever. And so I do not believe in increasing the cap for today. I think it needs a complete overhaul of the whole system. We cannot allow people are barely surviving in Northwest New Mexico by getting a cellular phone. They never had landlines their entire life. And now we want to increase their surcharge because Santa Fe does not have the right protocol. I can't accept that, Mr. Chairman.
Okay.
That's the way I see things. That's the way I see things. So I'm going to take a different route. I will not support the increase today. And I'm going to take a different route to get more solid answers with the way telecommunication carriers are conducting themselves. Thank you.
Okay. Certainly a valid point of view. And Commissioner Byrd, your thoughts?
Well, so I agree with Commissioner Vicente Aguilar. That's what I was saying. I think there's other ways to get to where we need to be without increasing costs to the people that we're here to serve. And so, yeah, I don't support an increase. There's other solutions that should be implemented first.
Okay. So anyway, I made a proposal that I would be okay with the more limited $10 million increase, and provided we add some audit capability here. So Commissioners Hall and Maestas, what are your thoughts on that?
Are we going to vote on these piecemeal, or this is a significant amendment? And so far, the amendments that we've discussed have been friendly, in my opinion. But I'm happy to make a motion to amend the proposed report to the legislature and recommend an increase in the Universal Service Fund in the amount of 10 million. So it would go from 30 million to 40 million.
Would you be willing to include a sentence that we'd like to set aside $75K for auditing our results, field auditing?
Sure, there's already a $25,000 budget for audit fees, but I guess that's of the financial nature, and it's not kind of a verification field audit in terms of what was built and how money's is being spent. So yes, I would accept that.
Okay.
So, Mr. Chair, I would acknowledge that that would be a friendly amendment
Okay,
with those two components.
okay.
Mr. Chairman, can I ask for clarification? Is this a temporary increase to 40 million? Because there was some discussion of it
Yeah.
being for 2 or 3 years.
Well, we were saying for 3 years.
3 years,
was
okay. 3
the
years. Okay.
original.
Okay, I lost track there. Okay, thank you.
Yeah.
So with that, you consider those friendly amendments?
Yes, sir.
And then, as far as I'm concerned, you had a discussion about all those other items that you clarified in the document. And thank you, Commissioner Hall, for being very focused on that.
You're welcome.
So it seems to me we wouldn't necessarily have to vote on all the specifics. We just give it to Commissioner Hall to do a single signature order when she's finalized all the details with Russell. Would that be?
Are we even considering those anymore? I thought we were just going to do a blanket 10%. So I don't know that we.
Well, didn't you have all those other corrections to the actual memo?
Oh, to the text. Yes, of course.
The text.
Yeah, sure. I can work with Russell on those.
So is that what we're saying here, Commissioner Maestas? Is that consistent with where you are?
Yeah, I'm fine with that. And I do want to also state that the northwest part of the state, District 4, is by far the primary beneficiary of the majority of not just the funds that are awarded to unserved areas, but those awards to underserved areas. And so, that's why I just wanted to break down by commission district just to see where the funds are going. And I'm okay. And I agree that the need, I agree with Commissioner Vicente Aguilar that the need is great. It's excessive. The need is excessive in the northwest part of the state, especially. So I think this additional funding will even help her district even more.
Yeah. No, and I tend to agree, but I completely understand where Commissioners Byrd and Vicente Aguilar are coming from. I'd certainly like to see a lot of cleanup too, but I tend to be more swayed by the argument that both you, Commissioner Maestas, and Cynthia make that, gee, that's going to take 2 or 3 years. And if we can do something in the meantime that helps, I'd certainly like to. So that's kind of what's swaying me.
Mr. Chair, can I have ask for another qualification of the motion? With regard to the set aside of $75,000 for audits, would this be specified for audits of the access reduction support payments? Because as Mike said, you could consider audits of the projects as well. One thing I'd like to note is, I'm sorry, two of the comments in the record actually ask for audits of the access reduction support payment amounts, because as you know, those payment amounts are calculated based on some historical issues that don't necessarily correspond to need. And I can say that without, I think, upsetting any of the rural ILECs who receive it, because they have actually claimed in the last rulemaking that the payments don't correspond to their need because they're too low. So, I mean, so it's I think everyone would agree that the way that the payments are not calculated, the payments in the statute are not necessarily calculated to don't necessarily meet need. They may exceed, in many cases, they may be too low. So, but I guess my question was, is it just access reduction support audits, or also audits of any projects, broadband program projects?
Yeah, in my mind, it would be funds specifically for, I'll just call them field audits of the broadband access, but also for the existing access line payments. It would be for both, as Mike suggested.
So both access reduction support and for audits of broadband program spending.
The
Not spent, but I think what we need to say is it's field verification, what we actually got. How many new lines did we actually get? Did we verify that the new lines are there? It could be something like we get a list of the new connections and they do some statistical tests or something like that.
Okay, so.
By actual calls or whatever.
Okay, and so it'd be like verification. It could be, you could call that, I think, an audit as well with regard to the the results that are coming about as a result of the projects in the broadband fund. And then on the access reduction support side, it would be a financial audit of use of the funds, giving you some more specific idea of how they're being used and the need for them for these companies, because what the idea behind them is that they're keeping them, they're needed to keep them in business. Does that sound right?
Mm-hmm.
Okay, thanks.
So with that,
Mr. Chair, let me get a clarification here. You
Sure.
mentioned something about a single signature order, but I'm not quite sure what for. I think we need to vote on this as a commission
oh yeah,
today.
we're going to vote. We're voting on this in just a second.
Right.
But then the actual follow-up, where the actual report goes out, and you've gone through all the amendments with Russell, or we can do that by single signature order rather than the commission having to get together and take another.
Certainly.
Yes, I think I can clarify, because Commissioner Hall, just to be specific, and just so all the commissioners understand, this is what I understand of it. The commission would be voting now on this motion for the $40 million cap for 3 years and the $75,000 for audits, et cetera. And then the specific revisions and also any other revisions that follow from that in terms of like if the commission doing a table that goes up to 40 million, showing the effects on the surcharge, I think that naturally follows from this vote, but we'd have to work out how to do that. And you and I would work together on how to do that.
Whoops, you're on mute.
That sounds fine.
Okay.
Okay, so I will make the motion that we put $10 million.
I thought I made the proposition already. I thought we were
Okay,
just amending
you already
my,
make the motion.
well, I didn't call it a motion, but it
Well,
was,
I made a motion, but Commissioner Hall, you took the lead, so I'll withdraw my motion and let you make it.
okay, fine. So I'll move to increase the cap by $40 million for 3 years. And specify that a part of the fund at the amount of $75,000 will go to auditing, access reduction, support payments, and field projects that have been awarded state rural universal service fund funds.
Okay.
Does that capture everything?
I'll second that.
Okay.
Yeah. Okay.
Under discussion, Mr. Chair, just
sure.
I'd like to suggest some changes to the evaluation criteria going forward. And it's not germane to this motion, but I'm just wondering if it needs to go into the report. I guess we shouldn't put anything in there that hasn't been decided, but I'm just going to make a statement that I do think that we should revisit the criteria. The only two things that I'm concerned about maybe adding, and we'll decide whether that's permissible. One is to also consider in the applicants their current active project workload as a disincentive. And then if we can consider quality of service, because it's ironic, as far as my district, telecom related complaints are exploding. And here we are making decisions on expanding service. And so are we expanding service and compromising quality of service? I just think that, we do need to start thinking about that, because I just see a degradation in the quality of service. But again, that's just based on, the complaint, the nature of the complaints and the number of complaints in my district. That's all I had.
Okay. If there's no further discussion, Mike, can you take the roll?
Commissioner, can you hear me?
Yeah.
Yep.
Okay. Sorry, I couldn't tell if I was unmuted. Commissioner Byrd,
No.
Commissioner Hall,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
No,
Commissioner Maestas.
Aye.
Commissioners, the order passes 3-2.
And, well, all we're doing is making a proposal here. Who knows whether the legislature will act on it. So, Commissioners Vicente Aguilar and Byrd, in the end, you may get your way.
Well, it certainly no animosity. I don't disagree with you guys. I understand the place you're coming from. I just think there's a better solution, and that's why I vote no.
Yeah.
But it isn't that I wholly disagree with where you're trying to go. So
Well,
anyway,
and I think that you helped moderate the proposal, both you and Commissioner Vicente Aguilar, with your comments. So again, just
And this,
good discussion.
Absolutely.
Commissioner Hall, you were going to say something?
I just wanted to say, I'm definitely not totally satisfied with the structure of the fund the way it is. Maybe I ought to sit down and pick Commissioner Byrd's brain about that, because I think it's far from ideal. This was only intended to be a stopgap for the crisis conditions we're under in terms of citizens. Hear more about his solutions. I'm sure they're probably pretty good. So we'll go offline with that.
Okay, so we're on to item 7 here, under discussion items, and docket 20-182 UT in the matter of the application of Public Service Company of New Mexico for approval of renewable power agreements and energy storage agreements and proposal for demand response plan pursuant to the final order in case number 19-195-UT. And Commissioner Maestas, Judy, and Michael, this is your baby.
Judy, do you want me to, or Mike, do you want me to kick it off, or maybe, or would you like to?
I think it would probably be good if you did, since I came in on a Monday night and I sort of got involved in this a little late, but so I haven't had a chance to discuss this with you.
Okay, well, Mr. Chair, I realize, look, we've already been briefed on supply chain issues that are going to impact the completion of replacement power projects for San Juan Generating Station. We also were briefed that this could reduce the summer, at least the reserve margin in the summer of 2022. I believe PNM briefed us and said that the average margin is around 13%. Ideally, it should be closer to 18%, but that they expect the reserve margin to be down as low as 5% in summer of 2022. And I think at that time, just getting the news, I think was surprising, but maybe it's time that we discuss the specifics of this and maybe get a little more granular in terms of exactly what is the extent of the delays. What is the plan to increase that reserve margin to temporarily replace what would have been online power through the replacement projects? And then what does this mean for abandonment, the abandonment deadline of San Juan Generating Station can the plant continue operating? And so I just think that it's time to maybe formalize this either in the form of a broadened inquiry through existing dockets or through bench requests. But I wanted to hear from maybe staff in terms of, what they've gathered from filings since we were briefed in general about those issues. And so that's my concern, Mr. Chair. I really think that we the commission need to be maybe briefed in greater detail as PNM has learned more information about these supply chain issues and the domino effect on other issues, as I mentioned.
Okay, thank you. And did someone from staff want to comment, John? Is John with us?
Yes. Yeah, good afternoon, Mr. Chair and Commissioner Maestas, commissioners. I don't have any, I have had just very passing informal conversations about this matter since the commission was briefed. And so I'm generally aware that PNM is very focused on this and trying to address it. So that would be my informal feedback. On a more formal note, I have expressed concerns about these delays in the PNM RPS case. It's in my direct testimony, and PNM has responded to those in rebuttal testimony, but those concerns are more related to meeting the RPS than to resource adequacy, but there's clearly a connection there. But I'm not going to go into the case, obviously, for ex parte reasons, but so I would leave it at that, Mr. Chair and commissioners.
And Mr. Chairman, this is Michael Smith.
Sure.
I think John's correct to stay away from the RPS issues in case 143. PNM actually, while I think either while or right as we were taking a lunch break, PNM made filings in that case that address those issues and Mr. Reynolds' testimony. So I think we need to confine those issues to that docket as it relates to the RPS. I think the concern that Commissioner Maestas identifies with regard to the issues that were previously came up in case 2182 relate to PNM's ability to meet the summer peak load. And that is what it has made filings in that case on, both in May and I believe the later one was in the end of July. And then PNM addressed the commission. I think to the extent that the commission wants that more granular explanation of what PNM's activities that it's undertaking are, I think that is properly brought in the 182 docket. And I think that's the way that this was noticed on the agenda. And I think that's correct. So certainly a bench request can be issued requesting PNM to make a filing in writing explaining the steps that it has taken. It's indicated in its July 22nd letter that it was exploring short-term and other available resources to meet the customer need for that 2022 summer peak, including, as it states, an assessment of market opportunities and alternative standalone projects. Given about 2 months have passed since the date of the filing in that docket, I think it would be appropriate for the commission to ask for another update on that. In addition to a written update, it certainly could request that PNM make another presentation to the commission following up on that written submission so that the commission can ask questions if it has questions. And I would just follow up with that PNM did state in that docket filing that if contract amendments or arrangements required that would require commission approval that PNM would submit necessary or appropriate notices or filings with the commission. I have not seen any application that would indicate that they're contemplating seeking any approval or providing notice of anything with the commission yet. So that's certainly something that a bench request or an order requesting information could request.
Commissioner Maestas.
Yeah, Mr. Chair. Yeah, that's a great idea, and I'd like to do that. But the other issue too that's been on my mind, and we're hearing about it more and more, are the global supply chain issues. And I think so far we've only really heard about these issues impacting replacement power projects in PNM service area. But I'm wondering what impact this is having on the industry across the state. And I don't like opening a docket just for the sake of it, but I sure would like to know, how it's impacting other parts of the state, other investor-owned utilities, heck, even co-ops, or is this supply chain issue isolated to certain companies? I can't imagine that. But I do think as a commission, we need to be aware of the extent of this problem and even get an idea what the other impacts could be besides replacement power projects for San Juan Generating Station, and get a sense for the duration of this. I mean, how long is this going to take? Will these supply chain issues nullify power purchase agreements where prices were secured for replacement power? Will that trigger a renegotiation? Because I assume if there's a lack of supplies, costs may likely go up. I just don't feel like me as an individual commissioner that I have a handle on the extent and the impacts of these global supply chain issues.
Mr. Chair.
Sure, Commissioner Hall.
So I just wanted to say that there may be some overlap here, and I think there might be some beginnings of information of the sort that Commissioner Maestas is interested in a docket that we opened earlier this summer pertaining to the utilities in our state's summer readiness, and that to be able to provide reliable service under the conditions, extreme weather conditions. And that docket is still open. And I was actually discussing it last week with General Counsel's office with Hans about whether to close it or morph it from a summer readiness into a more general resource adequacy type docket. And that might be, I don't know, that might be a docket that could look at what Commissioner Maestas just mentioned, which is the resource adequacy position of all the utilities in the state. That was the intent, really, with respect to the extreme weather period. So to me, it makes sense to continue it, and I'd be happy to do that. And I mean, it's nothing I need to do. It's just a docket. I mean, Commissioner Maestas, anybody could, issue bench requests through it or hold, workshops or, whatever we want to do in that docket. Something else I was going to say, but I can't remember it right off.
Commissioner Hall, so is that 21-00159? I think that's the open docket.
Summer readiness.
Yeah.
I don't remember the number, but I'll take your word for it.
I believe that is the correct docket number.
And, I've been, and and a discussion item I'll address later. The issue, I've been looking at the issue of resource adequacy, and I just wanted to mention in connection with something Commissioner Myers has just said. I discovered yesterday that the state of Virginia actually has a statute in place that requires that their utility companies provide an annual report to their commission and I think to the legislature as well on their ability and their resources that they have, but in connection with their ability to comply with their annual requirements, so that they can reach their clean energy goals by the period of time in which by the deadlines in which they have to meet them. So it's kind of fascinating, I think, that some states actually have at the statutory level annual requirements, and I think we should take note of that and feel like certainly at our level of the agency we should be able to require information about just such topics. What's the condition of the supply chain? What's the status of the supply chain for each utility and each type of resource they think they need? And what are their plans for meeting their load with a reasonable margin? And not only just what is the impact of plant closures, but other things like supply chain problems, weather issues, and whatever else. But especially since we have accelerated our RPS standard and we have deadlines, benchmarks that have to be met, I'm emboldened by the fact that other states feel that it's something so important that they require annual reports, not just to themselves, but to the legislature. And I think we should seriously think about doing something similar. So I'm in complete support with Commissioner Maestas's desires to do something more here.
Other commissioner thoughts?
Mr. Chairman?
Yeah, go ahead, Commissioner.
Yes, on this topic, it's clear that PNM is on shaky ground regarding the securing the replacement resources for the San Juan generating station. And I believe that a couple of months ago, representatives from PNM gave a report to the commission. And when we say we want to do more, I'm not sure exactly what Commissioner Maestas has in mind, but I've been reading about this, and this is a global supply chain challenge. It's across the board due to COVID-19. And that, I believe, my recollection is that representatives from PNM stated that during the open meeting. So that is just my remark on that, Mr. Chairman. I don't have exclusive information, but I'm tracking it. I'm reading about it at the national level. And if the statements are correct, that this is a global supply chain challenge, we ought to have our utility division give us more information about that, because I'm just getting glimpses of information here and there. Thank you. That's my remark.
Okay, thank you. Commissioner Byrd, any thoughts that you want to toss in here?
No, I agree. It's definitely a global problem. I think just keeping us apprised of where we're at on timelines, because it could become an issue, as Commissioner Maestas is pointing out, and just so we know, so we're not caught, behind that proverbial 8 ball.
Right. When we met, when we got our presentation from PNM, they freely admitted they hadn't resolved or solved the issue of how to be sure we have adequate reserves for summer of 22. And last week I had sent a note to Mark Fenton suggesting that they give us monthly updates on their progress. And he was quite happy to do that. He thought that was a great idea. And Mike, maybe you can answer this question. If we decide to go to something more formal and do a bench request, could we do a bench request that basically asks for monthly updates until this matter is resolved, so that we ask the questions we want to ask, and then just ask for the monthly updates as just sort of an ongoing bench request to be sure everybody is up to date on what's happening and we don't find ourselves caught by surprise at the last minute.
Mr. Chairman, Commissioners, yes, you certainly can ask for, you can certainly pose it in the form of a request for recurring updates.
Okay, terrific. Mark was completely open to it and actually thought it was a great idea, or at least that's what he told me over email. And you know, I don't know if he's listening in. Can we trust you? I think we can. So at any rate, I think if we put together an idea for bench requests, and Commissioner Maestas, if you have specific ideas you want to put in a bench request, maybe that's how we should structure it.
Yeah, I think that's a good plan going forward. I'll coordinate with Commissioner Hall, and maybe we can divvy up the bench request under appropriate open dockets as we've discussed.
Yes.
That would be fine. I suppose I should also mention something else that I'm gonna. I've asked to be put on. I want to have on the agenda for the 6th of October, and that would be a presentation from P&M about their the situation. I believe I mentioned in Commissioner Communications one time recently about the fact that they had a transformer that contained PCBs that exploded and created a contamination problem, but also a loss of service problem. And so I have sent a number of questions to Mark just through an email, but they may be better suited to and he responded, but they may be better suited to a bench request if I have follow-up, because that kind of incident really does result in lack of service and is a reliability problem. Apparently has occurred in other states. I'd heard that it occurred in California like a decade ago or something, and it was certainly treated as a reliability issue as well. So it's not quite the same thing as resource adequacy, but it could lead to loss of service as well. So that's a possibility. Maybe that's not quite the same thing as resource adequacy now that I've talked through it, but we can discuss. I'd be happy to discuss things like that with Commissioner Maestas.
Okay. Any further discussion on this item? Okay, let's move on to item 8 on the agenda. In the matter of a potential PRC Technical Advisory Services Group, Commissioner Maestas.
Thank you, Mr. Chair. The last conversation we had about our FY23 budget submittal, we were looking at the organizational chart, and I really felt strongly that we needed to start revealing our need on the advisory side for technical advisory services. And so, as I previously mentioned, it's not enough just to have an organizational structure box that's not filled in. And so I think it's time for us as a commission at least to begin a dialogue about what should those technical advisory services look like in the form of staff positions. And I think this is timely in light of the fact that, we are going to be defending our FY23 request. It's no secret that we have a lot of unfunded mandates. We have a backlog of rulemakings. We're relying on interveners for technical expertise and so on and so on. And so I think it's time for us to really be assertive and identify what other positions on the advisory side that should be in this new technical advisory services group. So far, the only position we have had in there and continue to have that remains vacant is an economist. And we've had discussions in the past about including an electrical engineer. We've talked about perhaps having a public policy expert in there. I feel we should add a ratepayer advocate in that group, but this is just me, Mr. Chair, and my colleagues. And this is something that perhaps we can have our assistants work on is, do we need a technical advisory services group that mirrors the utility division, which is on the advocacy side? Or do we need to maybe do a more in-depth assessment in terms of what different technical advisory services we might need as commissioners? And so I really, I'm adamant about identifying these positions to really start working on. This isn't reform. It's not expansion either. I hate that word. I know that, on paper to the legislature, it would be interpreted as expansion, but we've had these needs that have been documented clearly in the 2017 evaluation of our agency done at the request of Legislative Counsel Services. So, Mr. Chair, it's been a long day, but the point of putting this on the agenda is to start the dialogue. And I truly do think that we need to identify what those technical advisory services should be. And obviously, we're always going to need contract services. And so I think, our advisory services have to be a combination of in-house staff resources and consultants. I was going to say outhouse resources, but that wouldn't be very nice. But we do need consultant services.
We need outhouses too, just to let you know. Don't discount.
And then I guess the last thing too is we've been talking about reforming our assistant positions, and I think it's past due that we reclassify the assistant positions to add public policy requirements in there, maybe some collateral technical capabilities, because as I understand, we used to have two assistants, one subject matter expert or technical person and one administrative executive. But I think that coming up with this technical advisory services group and then reforming the assistant position, I think are interrelated and should be done at the same time. So again, Mr. Chair, I'd like to hear what my colleagues think, and I'm happy to see if we can maybe have utility division maybe advise us or make recommendations, or have our assistants maybe take the lead and work with utilities and querying individual commissioners to see what they expect in the way of technical advisory services. I pitched, a similar setup that the Arizona Corporation Commission has, but based on general counsel's recommendation, it may not work given our ex parte rules and our limited resources. So we're back to kind of creating this group, and I think we ought to forge ahead and start broaching this, this subject to the legislature sooner than later.
Commissioner thoughts or OGC thoughts?
Mr. Chair.
Commissioner Hall.
So I completely agree that we should move forward in formalizing the positions in a policy group that would advise the commission. it just imposes a complete hardship. It's just not appropriate for us to seek technical advice from staff. We can't do it. And so we need technical advisors and policy advisors. And I would very much like to formalize a reformation of our administrative assistant positions as well, along the lines that Commissioner Mayes just described. I guess the only area where I would have different thoughts would be with the, I'm spacing on the term, the public advocate. I think they should be, I definitely think we should have one. A number of states do. I don't know how many, but, and not a majority, I don't think, but the states that do have a very busy one. But I don't think they should be located at the commission because I think they need to be independent. Other states, I don't know if they have, I haven't heard of other states having them located in their commission, but I have heard of them located in an attorney general's office, which would be one place. But I also know they're also in some states a standalone entity. So I think either one of those structures would be fine, but they should be completely independent of the commission staff, of the commission itself, and just purely function as a consumer advocate. That's the term, consumer advocate. So yes, we should take some steps to make a plan to advocate to the legislature about it, because what we need is the funding, and we need to, I guess, seek cooperation and reclassifying jobs or creating new positions. And I guess we should definitely consult with Chief of Staff on those items, but I'm all in favor of moving forward on that. I think we're woefully behind a lot of states who can get things done faster, smarter. Well, I don't know about smarter, but they get things done more quickly and very thoroughly because they're staffed up to have enough people to puzzle through the difficult issues that we have in front of us. So I'm supportive.
Mr. Chair, before you, oops, there's a little echo there. Anyway, what I'd like to ask Mike Smith to do is to clarify in the statute who has the authority to hire advisory staff. I thought the last time I read that statute, it was the Chief of Staff. But can you clarify that, either Mike or Judy, who has the authority to hire advisory staff?
Mr. Chairman, Commissioners, my understanding is that the statute provides that the Chief of Staff hires the advisory staff, but I think that's primarily an administrative function in that sense. I guess the purpose of the question they're asking is sort of informs what my answer is in terms of, does the commissioner have the ability to choose his own advisor? Do the commissioners have the ability for input on who is hired as advisory staff? I would think that's the case, yes, and that's consistent with the statutes. In terms of, to the extent that you're including the commissioner assistants within the scope of advisory staff, and the idea of redefining the roles of the commissioner assistants, there are some statutory provisions that are somewhat obliquely stated and I don't recall off the top of my head exactly where those provisions are. I wrote a memo on it about a year ago, excuse me, that define the specific positions that are exempt from the State Personnel Act in service to the commissioners. And I believe they include an assistant and an administrative assistant. And I can give you a copy of that after the meeting.
Thank you. Go ahead, Joe.
Yeah, I was just, I'd like to hear from the other commissioners, what they feel comfortable doing here, but perhaps the chief of staff can be the focal point in this effort. And maybe our assistants can work with John Reynolds in the utility division. And if need be, can call, their respective or speak with their respective commissioners to get maybe an idea of what specific consultation services they need in the form of full-time equivalents or personnel. But I really think we need to get this, on paper, at least, the position and the function of it. That would be my goal if we could do that between now and maybe the middle of October, when we begin appearing before committees in case, this does come up, we'll have an answer.
And Commissioner, I asked this just for more, to provide you some more clarification. I was trying to pull it up while I was talking. The specific provisions on the hiring of advisory staff are in section 8813A, which states that the chief of staff may hire, with the consent of the commission, advisory staff with expertise in regulatory law, engineering, economics, or other professional or technical disciplines to advise the commission on any matter before the commission. And this includes not only full-time employees, but contract employees, because the next sentence states that this chief of staff may hire on a temporary term or contract basis such other experts or staff as the commission requires for a particular case. And then it states in section B that advisory staff shall analyze case records, analyze recommended decisions, advise the commission on policy issues, assist the commission in the development of rules, assist the commission in the writing of final orders, and perform such other duties as required by the chief of staff. So I think to a certain degree, consistent with the other provisions in section 8 with regard to the commission's powers to organize itself, this permits the commission to essentially create advisory staff positions as it sees fit. It's not necessarily tied to duplicating the specific positions that exist in the utility division or other divisions which serve as staff. But to some degree, this obviously might require the creation of or getting the approval to create additional FTEs at the agency. And obviously that's the issue that we have discussed a number of times. That really is the sort of the barrier that we experience in terms of bringing on somebody beyond the one existing economist position, which we've attempted to fill, but had several offers rejected due to the salary issues for that position. So in addition to the salary issues, we have the issue of obtaining funding from the legislature for creating these positions.
And Mr. Chairman, I keep bringing this up, but the 2017 evaluation by the National Regulatory Research Institute focused almost solely on the technical service needs of the agency. And so I invite, Wayne, if he hasn't already, to take a look at that. And I think it'll give him some ideas in terms of what technical expertise we need. Maybe we can, gather some best practices from other PUCs in terms of what advisory services are provided to those commissioners. But I think by mid-October, I think we need to have at least a rough idea of what this group comprises, this advisory services group.
So again, I believe we need those services. In fact, it's nothing new in a budget request. I know Sandy Jones several years back was asking for this in his budget meetings. And so this is not a new thing for the legislature. However, I don't think there was ever a good job done of really fleshing out exactly what it looks like. And it seems to me that's exactly what you're asking for, Commissioner Maestas. And I think it's a good idea. And my suggestion is that, maybe as commissioners, we should just kind of, we should get together with Wayne and, put together our ideas. And maybe he can summarize them and bring them back to us. And, I know I could just jot down a few notes and get them over to Wayne in 15 minutes time on this. Wayne, are you on, Wayne?
Yes. Mr. Chairman and members of the commission.
Yeah, what's a process you feel comfortable with, Wayne, for us to start putting this together?
Well, Mr. Chairman and members of the commission, first of all, I'm happy to take this on. I think it's extremely important. We've talked about it. You may have noticed by now, I don't really like to talk. I like to get things done. So I think the time for talking about this is probably at the end, and I think we need to move forward as Commissioner Maestas has suggested. I think I think as he has suggested, a good starting point for me may be to sit down with the commission assistants to start off with, and maybe you can kind of communicate through your assistants. I don't want to make you, of course, are free to communicate directly with me, and I'll do the same with you. But if you want to kind of have me start with your assistants and kind of get a rough sketch of some of the thoughts that I have and that you might have together, and then we can go from there. I do have a bit of good news in that FTEs are no longer included in House Bill 2, which means we don't need to go to the legislature to authorize or to create a position. If you want a electrical engineer advisor and we don't have one, well, we can create that. The problem, of course, is that we have to show that we have budget for it, and that is a bit of an issue for us right now, but we're trying to work through that as quickly as we can. And we think that by the fourth quarter of this year, particularly if we have some success with the legislature on some of these supplemental requests that we've made, that we hopefully by the fourth quarter, we won't be quite so budget constrained. But that is a bit of a departure from the past. I agree with Senator, or with, sorry, I give you a promotion there, Commissioner Maestas, that I don't like the word expansion either. But the legislature has kind of done away with that. And so I won't prolong this discussion, but that's how we can, I think, maybe get started, and of course include the utility division and Office of General Counsel. And I think a mid-October timeframe is certainly doable in terms of coming back to you with something that you can support. I fully agree that these positions should be chosen by you. They're your advisors, and I think it goes beyond just your consent. If I had my way, we'd get down to 3 finalists and then have you interview the 3 finalists, and you can choose who you want. I think that's the whole purpose of this exercise. But anyway, those are details we can work out and bring back to the commission for your consideration and deliberation.
So if I'm interpreting correctly, in terms of the positions and getting them adequate pay to get folks who actually take the job and can give us what we need, the real work is with SPO, not with the legislature, once we have the budget.
SPO and DFA, exactly. We have to work through both of them, but that constraint that has always been on state agencies isn't there anymore, and that's a good thing for something like this.
Yeah, sure is. So does it sound, Joe, that we just say that Wayne gets together with our assistant sometime in the next week or so, and then brings us some suggestions? I know I need to spend a little time talking to Robert to give him my thoughts. anything else that we need to do here?
No, I was just looking through that 2017 near evaluation, and it's chock full of best practices, mentioning what states have done, what their best practices are in providing advisory services to their commission. And it even recommends types of technical staff that should provide these services: economists, financial analysts, engineers, accountants, public policy experts. But the bottom line that this report concludes is that our lack of technical advisory services is compromising the public interest. And that was pretty much an eye-opening conclusion, or one of the conclusions to this report. And lastly, Mr. Chair, and I talked about this before, I'd like Office of General Counsel to take another look at our ex parte rules and see if there's any way that, we can at least assess them to see if they still apply, or if they're unnecessarily limiting our communications because of an overly broad interpretation of them. As I've reported, Arizona has a much more liberal ex parte rule. It only applies to active cases, not matters that are expected to come before their commission. So I think this issue is part and parcel with our ex parte rule. It's the reason why we are resorting to this. So I'd like Office of General Counsel to take a look at that and maybe give us any recommendations, if any.
Sounds good, and I'd agree, General Counsel. It'd be great if we could get any more clarity on those issues, then that would be helpful. I wanted to make a comment. Commissioner Hall was talking about consumer advocate, and you were as well, Commissioner Mastis. I think a likely response from the legislature at first blush would be that, well, we've already given that responsibility to the Attorney General. And statutorily we have. And I'll make an observation that when I read AG testimony in the dockets that I've been able to get more deeply involved in, it feels like their testimony more often is they're trying to balance interests rather than acting as advocates for residential and small business consumers. And my take is, well, that's the commission's job, is to balance interests. When we're talking about an advocate, they're advocating. They're coming up with proposals, original proposals. They're not trying to balance. They're looking out for their client's interest. And for God's sakes, that's what all the other testimony we get does. Utilities, they make strong proposals on their behalf, oftentimes ones that we have to scale back. The environmental groups do the same thing. We don't see that happening on behalf of consumers. And so I agree, we really need an advocate. I don't think they can really function on the staff, advisory staff to commissioners, because I think that would be a conflict for them to be an advocate and reporting to the commissioners at the same time. So to me, that seems problematic. But we need to find a place for that function, and it needs to be one that's truly an advocate, not someone balancing interests. And a couple of key cases we've looked at recently, quite honestly, if they were in the private sector, as a client, I would be suing my attorney, in this case, the AG, for malpractice, because I just can't see how they're representing the clients they've legally been assigned. And so we really need to work on that. And let's keep noodling on it. Other commissioner comments on this? Okay. Um, We're going to go on then to item 9. And this is discussion and potential action, distribution, transmission, grid modernization, data requirements, and regulatory challenges. That covers a lot of ground, but Cynthia will help pull it together for us. Commissioner Hall.
Mr. Chair, I'll do my best. And I would note that this item did arise as a conversation I had with you. And so you get some credit for that ambitious title. But this is a discussion I was thinking that we needed to have, and to my delight, there have been a couple of items already that Commissioner Maestas has brought up on topics that I thought we needed to talk about. So, this is a somewhat different topic, which is, it arose from my concerns and being involved in various rulemakings, wherein I realized that we just need to reach our goals in a more efficient, in a way that is efficient. And in the context of several rulemakings I'm working in, it's slow going, but it is the right methodology to go through. But I think we need to examine other avenues for getting information from utilities in a timely way that can contribute to our understanding of the situation they are in currently with respect to complying with ambitious clean energy goals and in the face of resource adequacy challenges. So I was thinking that what we need to do is discuss among ourselves whether we need to open dockets, investigatory dockets, for example, or inquiries into into various activities that we would like to learn more about. But we've just talked about doing that sort of thing. And I know you had specific concepts in mind, Commissioner Fishman, about data requirements, providing specific kind of informational demands on utilities, especially in the areas of distribution, transmission, and grid modernization, as the title says. And I think I had been a little exercised about the distribution grid issue when we talked last, and you about the transmission issue. But in general, they both fall under the rubric of grid modernization. And we have a statute on the books now that permits utilities to come in and propose grid modernization projects and then apply for rate recovery for the costs of them. So I think what would be helpful would be for us to kind of put our heads together and determine what types of projects possibly could be helpful and propose and invite the utilities to come in and make proposals. And when I say types of projects, I mean projects that would provide a contribution in moving forward in the areas of improving the distribution grid and the transmission grid. Because as I've discovered, and I know that you other commissioners who are involved in rulemakings have probably discovered, the grid at both the distribution and transmission level is wanting, and well, it's just, it requires updating and focused attention to the most efficient ways to be responsive to the climate change imperative mandates that we have. So would you like to make comments, Mr. Fishman?
Sure. It seems to me there's a few things going on. And going forward, I think investment in distribution transmission and grid modernization is going to go up. So right now it might be 35% or 40% of a typical utilities investments, but that could very well go up to 50% or more. And it's already that high at, I believe, SPS. It's probably even higher because of the geographically huge area that they cover for a relatively small number of customers. But with so much of the investment going on there, most of it, as Commissioner Maestas has noted, a lot of that distribution investment goes through a 440 process where the commission really, for all practical purposes, never really reviews the expenses or how they tie to anything. And we're going to be seeing grid modernization proposals going forward that from a commission standpoint, based on the information we have now, are going to just kind of look like a lot of disconnected one-off projects unless we have a better picture of the transmission and distribution grid now. What's out there, where there are congestion problems, where there's, substation improvements or expansions that are needed, and where there are problems that might be addressed through new storage or power line technologies, as opposed to the traditional solutions of putting in a new power line or reconductoring with a higher capacity power line. But that unless we see that bigger picture, we're not in a very good position to judge which projects make sense and don't make sense. I don't think that means that we have to approve project by project every $5 or $10 million project, but it does mean that we maybe should see packages of projects that we approve, and maybe that's on an annual basis or whatever. But right now we're just kind of flying blind, and that's where so much of the future investment's going to be. So I very much like to see us start to bring the appropriate information forward. And I think it's going to cut across a lot of our rulemaking. So we are looking at the 440 rule, and I know that Robert and Chris are looking at that together. And I know we're looking at adding a few things to the IRP to be sure that we're looking at those issues a little more closely there, because we need to get some visibility on these same issues in the IRP. And I think it's going to cut across a whole group of our rulemakings. And I think it's incumbent on us as a commission to really pay attention to it. One other area where I think it raises issues is the new laws allow us to do rate riders for these grid modernization projects. And what's interesting about these projects is that they'll be put forward with the idea of saving money down the road and hopefully increasing reliability at the same time. But when you do rate riders, you got to be really careful, because the tendency is to look at the expense of installing the item, but it ain't going to be till the next rate case when anything's available or any compensation comes back to consumers for the savings that these projects are generating. And we need to really look at these, if we decide to do rate riders in particular, we need to take a careful look and be sure that we don't end up charging consumers for the expense, but then they get this big delay before they get the benefits of the savings. And so as we're looking at this grid modernization process, I think we have to be very careful about how we put these costs into rate riders, or how we incorporate these assets inter-rate base. And I think as we go through these rulemakings, that's stuff we have to pay attention to as well. So anyway, I think that covers my main issues there, but I just wanted to bring visibility to that kind of big picture situation. Any other commissioner thoughts or comments in that area? Are Cynthia and I making sense? Are we just spouting a lot of, highfalutin nonsense? What are your thoughts?
Well, Mr. Chairman, I for one would like to know, like, what's the outgrowth or the result of this discussion? Like, what what potential specific actions can we take?
So I would, good question. I think that we need to be very, very thoughtful in our upcoming rulemakings, including the 441, about asking for bigger picture information to be sure that when we're considering investment proposals, we understand the picture that we're addressing instead of doing a bunch of one-offs that we don't really understand. I also think it's important to do that, to be sure that we handle the most urgent and also the most efficacious projects. Sorry for that word there. It's the one that popped to mind. Rather than just kind of hopping from project to project, which in effect is what we're doing with distribution right now. It's just kind of invisible to us, and gee, they show up on the balance sheet in the next rate case, and that's about all we know about it. And I think that's going to be maybe more important to regulation going forward than even choosing the generation assets, because it's how you put the whole system together.
And I can respond from my perspective in the interconnection rulemaking. It's just clear to me that problems that are arising in that rulemaking, which we knew would arise, and they existed in advance. We were all aware of the fact that renewable interconnection onto the distribution grid is, not possible in some areas of some utilities footprints because the lines are fully subscribed. It's clearly an issue where the distribution grid needs to be upgraded. And so while we're, making progress and making improvements in the rules, in the rule and the manual, nevertheless, the larger solution would be something that would need to be dealt with in the context of distribution grid modernization. So, so that's an area where I think I would, in terms of an action, I would, invite utilities to look at solutions that could be provided, that we suggest, or that the group suggests. Whoever is working and has an idea, they can suggest it in our work groups, and have solutions discussed in those contexts, as well as improvements made in the rules. We need to take advantage of the opportunity that rises in conversations that go on in these workshops that are very productive and thought-provoking, and use those as a springboard for proposals that we'd like to see the utilities come forward with. So that's the sort of thing I would like to see come out of this notion that we need a more integrated, big picture understanding of all the pieces that are being moved around by utilities, all the parts they're operating with, their new resources coming online, the resources they are retiring, and we need to know it. It's not good enough to get all that information in an IRP report every 4 years. It's really the kind of big picture we need to see on a more updated basis. And we need to be thinking as we see it about what can be done right now that the utility can do. And we have statutes that enable them to do it and even get rate riders for it, so that when 2040 rolls around, they actually will have reached 80% renewable energy. And then by 2045, we'll have 100% clean energy. Because unless we watch a lot more closely and make sure there's not all this scheduling slippage that we're seeing due to various things, supply chains, like we were talking about earlier, but many other things, we won't get there. So, so I'm just, that's where I'm coming from right now. That's my kind of a workshop that I'm coming out of right now.
So I'll throw out a specific example. This might make it a little more concrete. This ties to community solar. Is that, and you'll hear the term locational value of resources, or you'll see it in your reading. But based on congestion on the distribution or transmission system, you could put a community solar project in one place and completely overwhelm the system and have to make a lot of investments in transmission and distribution to support that project. Are there other places you could put that project where it might absolutely eliminate the need for having to either build or upgrade a certain kind of substation, or that it might it would essentially bypass congestion points on the T&D system. So if we can have a picture of what's going on there and where these congestion points are and where they aren't, we can start thinking of investments in projects in a much more comprehensive way. What is their impact in total system investment? Or did we make a big investment in a plant and then that created lots of T&D investment needs that if we had located it differently or thought about it differently system-wise, could have been avoided. So to me, a perfect example of that is what would happen with the community solar kind of project.
Yeah, 5% of PNM's feeder lines were, but I heard another presentation that, a 5 megawatt community solar project could take it there over so many more feeder lines. So knowing what remaining capacity exists in these feeder lines that maybe might not currently be at capacity would help. And my understanding is solar developers don't know that. If they make an interconnection application, and then there's another application after the interconnection. But anyway, there's a lot of mystery regarding the capacity of these feeder lines, but it's not revealed until well into or past the interconnection application process. So I think there's a specific example where I think we need more information on the limitation of the grid, because this is going to send people scrambling, and it's going to frustrate a lot of solar developers that that get so far down the process, and then they realize, 5 megawatts is just going to trigger at capacity, and you can't do it. I'm making an extreme example, but I do understand kind of the process and how the mystery regarding limitations of these feeder lines can really disrupt the application process for a solar developer.
And that's exactly, I think that's exactly the concept I'm trying to convey. And that, so even in the community solar rule, I think there's a place for us to be considering these issues. And I don't think there's any one docket you do to fix this. I think it's just something that we have to realize is an underlying major transformation going on that's going to underlie a lot of these dockets. And of course, another one that's going to be impacted tremendously is the transportation electrification dockets.
Yeah.
I mean, that's going to have huge distribution impacts. We better think about what this whole picture looks like and not just kind of stumble into it.
And actually, Mr. Chair, that second stage after the interconnection is the pre-application. And my understanding is that's when the true limitations of a proposed location and feeder line is revealed, whether or not it can accommodate, let's say, a community solar project. And I think the other issue too is, as I understand it, the interconnection applications, it's public information. I don't know, it'd be nice to see it on a map to see, what the interconnection queue is and potential locations. I believe if they've already considered a location, I think the pre-application information is not public, but I think there's some information I think that would really help us to see where the interest is, where the trends are. That way we can start, as you said, have context and start focusing on, bigger issues and bigger solutions instead of dealing with this on a project by project basis.
Cynthia, I think we succeeded, at least with Commissioner Maestas.
Good. Take what I can get.
But you know what I suggest though is maybe if you two can put together like an abstract of the issue and then and keep this as a working white paper for the commission, and then we can start identifying specific actions, whether it's data requirements or additional reporting. Let's keep this thing alive, but let's start with a written abstract of it and then potential actions, and then we can continue from there.
I like that. That's a good idea, because the challenge is how do we interact on this? We have to do it, on the bench. So having a written document is a good platform to continue to communicate. Great. Thank you, Mr. Chair.
Okay.
Thank you guys for bringing it forward. Thank you.
Thank you, Commissioner Maestas.
Any other commissioner thoughts, comments on this topic? Okay. So going to item number 10, discussion and potential action on possible NMPRC support of Western States comments regarding governance of the Northwest Power Pool's Resource Adequacy Program. Commissioner Hall.
Thank you, Mr. Chair. And, I feel it's unfortunate really for this to be the last item on the agenda. But fortunately, the comments that were to be prepared that I was intending to present to the commission today are not yet prepared by the Western states who are working on them. So in large part, I'd like to postpone this discussion until next week. But I would like to at least explain what this is all about, because looks sort of foreign compared to most things we talk about. But I'd like to explain. In the course of my membership on a board called the YRAB, it's the Western Interconnect Reliability Advisory Board, which is a board that exists to advise the WEC, which is the WECC, the Western Electricity Coordinating Council, on matters of reliability. It has come to my attention that an entity called the Northwest Power Pool has been working for several years on developing a program whereby voluntary states in the West could participate by through transactions, mostly bilateral transactions, in order to create a mutual resource adequacy support environment, group, I guess. And it would involve all the participants coming into the organization with having planned and assured that created or acquired sufficient resource adequacy to meet their own needs going into either the summer or the winter seasons, where there are generally more resource adequacy challenges. This would be an organization that would be very different and is distinguished from a regional transmission organization, which does manage resource adequacy and conducts a market that is different from a group of bilateral trades. And this is not an organization, this is to be distinguished from the Western Energy Imbalance Market, which is a market that exists to help achieve balance on a very short through trades that are conducted either within a 5-minute or 15-minute time span. For example, if a utility has extra energy left over at the end of the day, they can get on and sell it. Or if they need capacity and they want to buy something, they can get on and do a quick trade. But this resource adequacy effort by the Northwest Power Pool is something that requires utilities come to having, planned 7 months in advance at a minimum to make sure they have adequate resources before they even can participate. So I had my Collins send out a paper, an academic paper that was written entitled Energy Analysis and Environment. Wait a minute, that's the organization. It's entitled Implications of a Regional Resource Adequacy Program on Utility Integrated Resource Planning. It's written by people from Lawrence Berkeley National Laboratory and University of Texas, Austin, and also the Western Interstate Energy Board. And in it, I sent it out because it was a good discussion of the notion of the topic of resource adequacy. And they specifically describe the program of the Northwest Power Pool. And they also describe how NRTO, the Southwest Power Pool, handles resource adequacy as well. So, if you have some time and can devote to reading some of this article, it's actually really well written, and it's in terms of being readable. It's pretty simple, straightforward descriptions. It's not too wonky. It doesn't have any formulas in it. It's not wonky. It's just a real clear description. So that would kind of help you understand what I'm talking about when I come next week with comments. But just real briefly, what I found myself doing as a member of YRAB was pooling our resources, the members of YRAB, that is, the Western States Commissioners, to assist in responding to a request from the Northwest Power Pool to make comments on their governance proposal for this organization going forward. They're in the process of creating it. I guess they've established the design of it, but now they are working on the issue of governance, and they were seeking input from commissioners from the Western states. So they approached YRAB and the also the Western Interstate Energy Board to ask other commissioners to help with comments. So I got roped into that, and they have gotten partial, comments in a sort of disaggregated form right now from various commissioners, and the Western Interstate Energy Board is putting them together in a more coherent form, which they say I'll be able to get before our open meeting next week. So, and the reason they're putting them in written form is because the Northwest Power Pool would like to see them in written form, and the Western Energy Imbalance Board, which is actually it's a support organization for the YRAB organization that I'm in, and for several other Western grid related organizations. They were encouraging commissioners to get the support of their commissions if it's forthcoming on these notions of better governance for this organization, because governance can be a problem, especially in more complex organizations like RTOs. But to the extent we can provide them feedback and anticipate what it might be like if the utilities in our state were a member of such an organization, which might be not a bad idea if they need to, if utilities like PNM need to try to ensure better resource adequacy, then it makes sense for the Western states commissions to have input on what the governance constraints and structure ought to be. So I'll bring it next week, and if you get a chance to read this document, I think it'll help tee up your thoughts, and hopefully they will have comments that we can all think make sense. And it would just be for discussion next week, no action, I don't think. We might as well say discussion of potential action, but I will circulate them. I'll have them circulated as soon as I get them. And I was told that would be by the end of this week, so we'll see. So that's where I am on that. And if anybody wants to make any comments, that's fine. I'd like to hear them.
Commissioner Vicente Aguilar. Commissioner?
Great. Thank you. Yes, can you hear me?
Yeah.
Yes.
Yeah, okay. Yes, yeah, certainly. Once the information is available, I like to read more into the background information. So that's my comment on that. Thank you.
Thank you. I appreciate it. Nobody else is even going to promise to read it, huh?
I promise to read it, and it's important,
Okay.
because how do we play in the sandbox with other utilities, and how do we collaborate for the most effective operation regionally? So it's pretty key.
Well, I guess
Commissioner Maestas, he had his hand raised for a second there.
No, it was just me promising to read it and actively participate next week.
I think he swore an oath to. And I guess Commissioner Byrd doesn't need to say anything because he already knows, as a member of the Regional State Committee on the Southwest Power Pool. He already knows all this stuff. Am I right, Commissioner Byrd?
Yeah, we'll go with that story.
Thought you'd like it. Okay. So thank you, Mr. Chair. I'm finished with that.
Thank you, Commissioner Hall.
Yeah.
Communications with Chief of Staff.
Mr. Chairman, I think I've said about all I need to say today, but I'm certainly happy to answer any questions. I don't really have any updates from last week. I think we're doing fine. Doing just fine.
Okay. Thank you. Communications with general counsel.
I don't believe I have anything today either.
Commissioners, we wore everybody out. Communications with commissioners. We wore ourselves out.
Yeah.
Okay, guys, terrific meeting. Thanks. And we are adjourned.
Thank you.
Thanks. See you guys.
See you.
Bye.